you know when we're being live streamed, and I will do the court cry.
Thank you.
The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to this session of the Massachusetts Appeals Court, which we are conducting in this format due to the ongoing pandemic. Even though we are conducting court in this way, all the ordinary rules of argument that would apply, including that each side gets only 15 minutes to argue with no rebuttal. With that, I'm going to call the case of Commonwealth versus Antonio Diaz, case number 2019 P1677. And we're ready whenever you are, Attorney King.
Thank you. May it please the court, my name is Jinho King and I represent the defendant Antonio Diaz. We ask the court to reverse the order denying his motion to withdraw his guilty pleas under a claim of ineffective assistance because it would have been reasonable under the circumstances for someone in his shoes to have rejected the pleas and have gone to trial. Now, because there does not appear to be much of a dispute over either deficient performance or the existence of special circumstances, I'd like to focus most of my time today on the question of reasonableness in the prejudice analysis, unless, of course, the panel has any questions on those other issues. So I think that really the question that we're facing today is how the district court and whether the district court abused its discretion by giving Judge Dineen's findings overriding weight in its analysis. Because on the one hand, the district court did find special circumstances, but then relied on Judge Dineen's findings on the giving of warnings by the court and some statements about perhaps it would be speculation to see if there would be a better outcome had there been better performance, and using those things to override special circumstances. And we believe that that kind of analysis does not give proper weight, substantial weight, as the SJC has stated, to the question of special circumstances, and it ignores some other factors that are also important in this kind of analysis. So,
do you think that the prejudice inquiry is subjective, objective, or both?
I believe that it is both. And I think that with regard to what the district court found, I don't think there's much question that it believed that Mr. Diaz believed that he would not have wanted to plead guilty had he known. And so the question is more on the reasonableness, which would be an objective standard.
Okay, so it's so in your view, to the extent that there's a subjective component to prejudice, the judge found that, and it's just a question of whether the judge could, within his discretion, find that subjective, I guess, prejudice was objectively reasonable.
Right. So the question is whether, given these circumstances, would someone in Mr. Diaz's shoes have been reasonable in rejecting those pleas and proceeding to trial?
So what do we make of this language, which I understand to be the test, which is whether there is a reasonable probability?
I think that's, it goes towards this idea that this is an objective as opposed to a subjective question. And when we talk about reasonable probability, I think it's instructive when we look at the facts in the case here. If we're putting someone in Mr. Diaz's position, we're talking about someone who has lived his entire life save for 2 years in the United States. Someone who didn't speak the language of the country that he would be deported to, who his entire family was here, whom he supported and they supported him, that his girlfriend was here and had just given birth to, or was about to give birth to their child. These are the circumstances that someone facing the question of whether to plead guilty would be in. And then on top of that, we're looking at whether there would be, what kind of risks he would be facing had he gone to trial. And that was something that the district court didn't address in its decision, right? The question of what kind of penalties.
Is that the part you think that the judge here adopted from the previous finding?
I don't think that that's exactly what he adopted, because he adopted this idea of maybe he wouldn't have gotten any better outcome, right? But that's not the test. The factor is not that he would have received a better outcome. It is whether there's some probability or possibility that he would have received a better outcome. And that's just one of many factors, right? And part of this analysis, if we think about it objectively, any decision to plead guilty is a balancing of competing factors, right? You know, the question of how much of a penalty am I facing if I go to trial versus if I plead guilty,
so,
right?
So I think it's because it's this kind of balancing of factors that it's a discretionary function. And you would agree, would you not, that the standard of review for us is abuse of discretion?
I would agree that it's abuse of discretion, and it is a question of balancing of factors, but where the district court is not applying the right kinds of weights to the right kinds of factors, there is an abuse of discretion, and that's from LL versus Commonwealth. And so I think that in this circumstance, in these facts, the fact that the district court didn't really even consider what difference it would have made to a defendant in Mr. Diaz's position facing the question of pleading guilty is an abuse of discretion, right? Because the question that wasn't answered in the district court's decision is, so let's say he goes to trial and let's say he is found guilty on everything. What would his sentence have been, right? And the answer to that is probably not that different from the sentence that he already received, because he already received the mandatory minimum sentence on the counts that required that. And he would have been parole eligible even if a district court judge decided to sentence him to the max on every single offense and ran each of those sentences consecutively, which again in the district court is not something that is very common, particularly for someone who had no prior criminal record. So we're talking about a set of circumstances where the chance of him receiving a much heavier sentence are minimal as compared to what would amount to something like a life sentence away from his family by deporting him.
Counsel, is that correct if the gun charges were still included?
Well, the gun charges were dismissed over the Commonwealth's objection, so they were not part of any guilty plea, and they were dismissed before the global resolution of all the other cases occurred.
But they were part of his thinking, because were they not? Because the record shows that they were all resolved on the same day and
Yes.
part of the same discussions with his counsel.
Yes, absolutely. So they absolutely were part of his consideration because he was concerned about deportation.
But why would they also be part of the Commonwealth's consideration? Because the way I read the record, the negotiation of the resolution on the remaining counts appeared to be, let's say, somewhat contingent upon the Commonwealth's agreement that the gun charges be dismissed. So why isn't that all part of a single package?
I don't think that the record reflects that they were part of a single package simply because the Commonwealth didn't want the gun charges to be dismissed, right? Unlike those other charges that were dismissed as part of those 6 cases that were part of the plea, the Commonwealth objected to the dismissal of the gun charges. And it was—
This was a 2-step process, right?
That's
First,
right.
the judge found that there wasn't a witness available for the Commonwealth to prove the gun charges, dismiss them. Then there was a negotiation about a plea. Is that correct?
That's my reading of the record, correct. And so given that context, right, the gun charges don't really factor into this discussion other than to say that is evidence of how much the defendant cared about immigration consequences, right? His instructions to his attorney in the facts that the district court credited were that I don't want to plead to anything that would get me deported. And so again, if we're talking subjectively, he obviously satisfies that based on the evidence here. And the gun charges were dismissed.
Do we have any cases where there was a failure, there was a Padilla failure by counsel, but the defendant unambiguously received immigration warnings during the colloquy, where we have nonetheless said that that does not satisfy, as a matter of law, the prejudice prong for the attorney's shortcoming?
If I understand your question, it's whether we have a case where alien warnings were given, but prejudice was nonetheless found. And the answer to that is yes. So a case like Commonwealth—
That's not exactly my question. My question is where the warning, because the warning was given by the judge and on the green sheet, and he acknowledged it, that we say, as a matter of law, that's enough to obviate any prejudice that might have flowed from the attorney's failure to give immigration counsel.
Oh, okay. So I think the answer to that is no. I don't think this court or any other court has said that just by giving an immigration warning that you obviate any prejudice, right? And there are cases to the contrary where instructions, I should say in the colloquy, alien warnings were given where prejudice was still nonetheless found.
Okay.
What's your best case for that?
I believe Commonwealth versus De Jesus. I believe that's cited in the briefs. And that is a case in which alien warnings were given, but the fact that they were given did not overcome prejudice.
You would agree that the judge could look at the fact that the defendant received alien warnings at the time of his plea in the assessment of whether there was a sufficient showing of prejudice from the counsel's failure to adequately advise him about immigration consequences.
Yes, I agree.
Okay, so
because this is totality.
Error? So what is the error here in taking into account Judge Dineen's rulings?
The error is not taking them into account, because we're talking about totality of circumstances. The error is giving them overriding weight over factors that the SJC has identified as things that should be given substantial weight. The question is whether this falls outside reasonable outcomes, right? So if
you're not saying he couldn't look at those, you're just saying that he couldn't weigh them the way he did.
That's right. That's right. It is legally impermissible to weigh them the way he did, and that's really the question that we're looking at in this appeal. Whether you can take something like the giving of alien warnings and outweigh substantial special circumstances, outweigh the fact that the potential penalties he was facing, had he been convicted of everything, weren't that serious, right? And then on top of that, the fact that the district court judge himself acknowledged that the strengths of the case, each of the cases against Mr. Diaz had their strengths and weaknesses. This was something that he said orally from the bench. And the district court judge stated that in his view, the likelihood of Mr. Diaz being convicted of all 6 was likely 0. And so there was this kind of acknowledgement that the cases were not overwhelming, that there were, whether factual or technical defenses, or even practical defenses. When you take those into account, when you take into account the kinds of penalties that he could have faced, and then take into account that he'd be going to a country that he didn't know, they didn't speak the language of, that he didn't have family there, at the age of 20, right?
Would a single conviction have had the same result? Any one of these could have resulted in deportation, is that correct?
I think almost every single conviction, because most of these are drug convictions that would have been aggravated felonies, and the others would have been crimes involving moral turpitude, so I see that my time has expired. Unless there are further questions, we'd rest on our briefs.
Counsel, I just wanted to say I found the tables about the convictions in your brief very helpful, and the hyperlinks also really nice.
All right, thank you.
Thank you very much. Attorney Kelly.
Thank you. Good morning, and may it please the court. Kira Kelly on behalf of the Commonwealth. The defendant pleaded guilty almost 24 years ago to various drug and property crimes, and is now appealing from the denial of his 7th set of motions to withdraw his guilty pleas and for a new trial. And he raises one issue on appeal, whether he was prejudiced by plea counsel's performance. It is the Commonwealth's position that the motion judge acted within his discretion in denying the defendant's motion to withdraw his guilty pleas, where the defendant has failed to show that he was prejudiced by the performance of his attorney. As counsel pointed out, the Commonwealth has conceded in its brief a number of issues, significantly narrowing what is in dispute. We have conceded that it was proper for the motion judge to find that the performance of plea counsel was deficient under Padilla, that the defendant raised a baseline issue of prejudice, and that it was proper for the motion judge to find that the defendant had established one of the Clark factors, that being special circumstances. This has narrowed the issue of dispute to the remaining issue that the Commonwealth is contesting, which is whether it was an abuse of discretion for Judge DiLorati to find that despite having established special circumstances, the defendant was not prejudiced by counsel's performance. It's the Commonwealth's position that he properly applied the totality of the circumstances test, which is the standard for reasonableness, when he made the finding that the defendant was not prejudiced by the performance of counsel. Judge DiLorati noted in his findings that the defendant had failed to meet his burden to prove that there was a reasonable probability that but for counsel's errors, he would not have pleaded guilty and would have insisted on going to trial on all 6 of these matters. It's the Commonwealth's position that this test was appropriately applied according to the framework as outlined in the case law, both the Lavranenko case and the List case, which permit the court to consider any factor bearing on the ultimate issue of prejudice. These 2 cases provide a non-exhaustive list of factors that the court may consider, and also point out that the 3 Clark factors may again be considered at this second stage of the analysis. Some of the factors that Judge DiLorati did rely on in his findings that are significant, I would suggest to the findings that he made, was first that the defendant had failed to show that he would have had any viable motions or defenses in these cases. He incorporated into his decision the findings of Judge Janine, who was the plea judge and also heard the defendant's first motion to withdraw his guilty pleas. Judge Janine found that there was no specific evidence to suggest that the defendant did not commit the crimes to which he entered pleas of guilty, that some particular technical defense was ignored, or that the sentence imposed on several serious charges was unjust. And where Judge Jeanine was both the motion judge and the plea judge in this case, his findings are entitled to substantial deference, and those findings were again incorporated into the decision of Judge DiLorati from 2019.
But was that really appropriate to rely on Judge Jeanine's finding when Judge DiLorati was presented with additional information regarding the potential defenses in each of these cases?
I think it was appropriate for him to incorporate it and consider it. He certainly didn't make his ruling based only on what Judge Jeanine found. Again,
I would simply say that there's nothing put forward regarding any potential defenses or technical deficiencies. There was a proffer put forward on each and every case as to that there was, a case based on a fingerprint and nothing more than that. There was the stopping the car without and the exit order. I mean, there were specific proffers on each and every charge. To rely on Judge Jeanine's assessment that nothing was put forward, that sort of flies in the face of what actually happened, don't you think?
I don't think he relied entirely on what Judge Jeanine found. I think he incorporated his findings as the plea judge and the initial judge to hear the initial motion, but he also considered the additional evidence that was presented to him at the hearing and prior to the hearing that took place in 2019. And I think that's demonstrated by the fact that Judge DiLorati he credited both the affidavits that were presented by the defendant and by plea counsel. And for the first time, he made a finding that counsel's performance was deficient. That was a finding that Judge Jeanine had not made because presumably those affidavits were not available to him. The affidavits were written in 2017 and 2019. So it shows that Judge DiLorati did appropriately also consider new information that had been provided to him prior to and during the hearing that took place in 2019 and didn't just rely on Judge Jeanine's findings, although I think it was appropriate for him to consider those findings as he was the plea judge. He didn't entirely rely on that and ignore additional information that was provided to him later in time.
What was the legal framework for assessing the defendant's first motion when it was made? In other words, what was the legal articulation of how to evaluate prejudice at the time Judge Jeanine made his ruling? It was certainly pre-Padilla.
It was. So it wasn't the same requirement that counsel have to advise.
We didn't have Clark. We didn't have any of the subsequent articulations of how prejudice is to be evaluated or assessed that we've had subsequent to Padilla, correct?
Yes.
So why doesn't that make a difference here? When you look at doesn't that undermine the validity of relying on Judge Jeanine's assessment of prejudice? He was doing something under a different framework.
It was a different framework, but what he was looking at are some of the factors that it's still appropriate for the court to consider now. So although perhaps, the one point of saying looking at defenses or available motions, that's certainly not enough to find that there was no prejudice, but it's still a factor. Under Clark and under Liss, it's still a factor.
But he didn't limit himself to, I don't think the second judge limited himself to simply relying on the subsidiary facts found by Judge Jeanine, such as that there were no viable defenses or the facts weren't contested, but rather it appeared to me that he relied upon the ultimate conclusion that there was no prejudice shown.
The way that I read Judge DiLorati's decision is that he came to that conclusion on his own in his actual conclusion, he even cites that it's under the totality of the circumstances, that he is applying that correct legal standard now by looking at the entire circumstances. He made his own assessment based on the record that was before him. And as I stated previously, that notably involved crediting the affidavit entirely that the defendant submitted and the affidavit that plea counsel submitted. And that's why there was a finding in this case of deficient performance. But he also looked at all of the remaining record that was before him and coming to that conclusion. In addition to the factor regarding any viable motions or defenses, he also looked at whether the defendant would have been able to negotiate a plea without deportation consequences. There was nothing in this record to suggest that the Commonwealth or the court would have accepted a more favorable or recommended a more favorable disposition for the defendant.
Why is the issue limited to could he have gotten another plea or a better deal? Isn't the question really is directed towards the decision to reject the plea and go to trial? Maybe he couldn't have gotten a better plea. And if he couldn't have, he would have gone to trial. Isn't that the relevant inquiry?
Yes, but it's our position that under the totality of the circumstances test and all of the factors that can be considered, that's, again, one of the factors that the court could look at and the court did look at in this case. And I think one of the other things that the defendant ignores in his argument is that these 6 cases, they were all separate cases. They related to different facts and circumstances. There were different dates of offense. There was no, I don't see any possibility that these would have been joined for trial. So if the defendant were to have gone to trial, he would have had to go to trial separately on each of these 6 cases. And contrary to what the defense has argued, I don't see how it's likely that he would have received concurrent sentences on every one of these cases if he were to be tried and convicted and sentenced separately.
What do you think his exposure was? Because the defense is basically saying it was between the 2-year plea he took and 2.5 years.
I don't think that's necessarily true because these are separate cases committed on separate dates that he could have faced 2.5 years on each of these cases from and after. I mean, there's always a possibility that he could have received consecutive sentences within each individual case. I don't think that's a very likely possibility, but for the 6 separate cases, if he were sentenced and tried separately, he certainly could have received consecutive sentences on each of those because they did not relate to one another in any way that I can see.
Counsel, could you address your brother in his reply brief talks at length about the Lee case?
Yes.
And you, of course, didn't have an opportunity to reply to his reply. Could you address that argument, the Lee case, and how that aligns with this particular case?
So the Lee case, it's the Commonwealth's position is distinguishable in important ways. Although there are some factual similarities, it is legally distinguishable and also factually. The legal distinction is that in Lee, the government was asking the court to adopt a per se rule that a person without viable defenses could not show prejudice of his denial of a right to trial. And that's not present here. The Commonwealth has not asked the court to adopt any kind of per se rule, and that was not applied by the trial court judge in this case, whereas in the Lee case, that was the standard that was applied by the lower court. But notably, the factual differences in Lee are that, as I was just discussing, in this case, the defendant was dealing with several sets of cases with a number of charges, some that were dismissed in consideration of the plea, some that were placed on file, and he potentially avoided a much longer jail sentence. In Lee, the defendant was facing only one criminal charge. So there was no possibility for a much lengthier sentence in the sense that there was here in this case. Additionally, in Lee, and this is one of the other factors that Judge DiLorati also pointed out in making his decision that I hadn't discussed yet, were during the plea colloquy in the Lee case, when the defendant was given the immigration warnings, he indicated to the court that that was going to affect his decision to plead guilty, and then spoke with his attorney and did end up pleading guilty. But he spoke up during the plea colloquy when those warnings were given. And to the contrary here, Judge Janine made a factual finding that during the plea colloquy, he gave the defendant the warnings and he said nothing about the immigration issue during the colloquy. So that is a factual distinction in terms of him voicing that concern to the court. And just to address a point that was raised earlier, I would point the court to the Clark case in footnote 20. In that case, there's actually a discussion about the fact that if the warnings, immigration warnings are given during a plea colloquy, that's certainly not a substitute for counsel's advice, but it is a relevant factor to the prejudice inquiry. And I would suggest that that's something that Judge DiLorati properly, again, considered here in making his determination that the defendant was given those warnings on 2 occasions, and also that he did not raise any concern as the defendant in the Lee case did.
Do you agree with your learned colleague's argument that the gun charges were just dismissed over the Commonwealth's objection and weren't part of the plea?
That's my understanding of the record, yes, that was dismissed first over the Commonwealth's objection because they were not able to proceed to trial, and it was subsequent to that the plea discussion was held. And so after viewing the totality of the circumstances in this case, the motion judge, it's the Commonwealth's position, acted within his discretion and properly found that the defendant failed to meet his burden of proving that but for counsel's errors, he would not have pleaded guilty and would have insisted on going to trial. So I respectfully request that the court affirm the denial of the defendant's motion to withdraw his guilty pleas.
Thank you. We have your argument. Let me see if there are any further questions. Seeing none, thank you both. It's an interesting case. We were aided greatly by your argument, and the case is...
I can't hear anything.
Just a moment.
Okay, sorry. I can't see anything either. I just see the word Zoom.
If you Alt-tab through different screens, can you come back so that you can see?
I'm not exactly sure how to do that, Your Honor. I'm sorry.
A key that says Alt-ALT. You hold that key down and you push the tab key, it will cycle through the different windows that you have up.
I don't see an Alt key. I don't know what that means.
The case is now being recorded.
Should I get out and come back on, Your Honor?
No, let's hold on the recording here. Let's stop the recording for a minute.
Okay. I can put you back in the waiting room.
Could you do that and then bring me back out? Because all I see is Zoom.
Good morning. Welcome to this.
Not yet. It's not yet.
Sorry.
The case is now being recorded.
Good morning and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format due to the ongoing pandemic. The panel this morning is with me, Justice Henry, and Justice Singh, and my name is Gabrielle Wolohojian. Although we are conducting court in this format, all the ordinary rules of argument apply, including that each side gets 15 minutes to argue with no rebuttal. With that, I'm going to call the case of Commonwealth versus Peter Hurley, case number 2020-P0502. Attorney Maddox, we are ready whenever you are.
Good morning, Your Honors. My name is John Maddox for the defendant Peter Hurley. Mr. Hurley is making a contract argument that would reduce his OUI 5 conviction to an OUI 4. He is contending that a plea agreement is a contract and that Massachusetts contract principles apply to the plea agreement. 2 contract principles apply in particular. First is that the rule is that existing statutory law is an implicit term of a contract. That's the Feeks and National Association case. The second rule is that there must be an express reserved power in the contract in order to change a contract term. although that is Massachusetts contract principles, there is case law that also says, the Albert A case and cases following it, there has to be an express promise by a prosecutor to apply existing statutory law to a plea agreement for future use. So I'm suggesting that there is precedent going both ways. We're supposed to be applying Massachusetts contract law, and yet there's also this other seemingly contradictory rule, and I'm suggesting that the panel needs to resolve that because there's precedent for both sides.
Attorney Maddox, may I ask a question that pertains purely to the record? Can you please give me the page number or the page numbers on which I will find, or we will find, the contract to which you're referring?
That's record appendix pages 52 and 53.
Let me look at that. I'm there. That's the docket sheet?
Yes, that's exhibit 2. It's the OUI 3 plea agreement from the year 2000.
I don't see a plea agreement there. I do see a docket sheet. Where's the plea?
There is no plea agreement, but this was a guilty plea. It indicates there was a guilty plea. There's an inference there that there was a plea agreement.
Where do you draw the inference? Can you tell me where you draw the inference from? I see.
Yes, it says under disposition method, it says guilty plea.
Yes.
Beside it, it says finding guilty. That is a guilty plea. That is by plea agreement.
Well, but I understand it's a guilty plea. It's the by agreement part that I'm struggling with.
I'm suggesting that there has to be some sort of agreement to plead guilty. You can't have a guilty plea without a agreement to plead guilty.
But the terms with whom? With the prosecutor?
Yes, Your Honor.
Are you saying the prosecutor controls the ability of the defendant to decide to plead guilty?
No, Your Honor. The judge accepting a guilty plea accepts that based on some sort of an agreement.
Who's the agreement between?
The agreement is necessarily between the Commonwealth and the defendant.
And what were the terms of the agreement?
That's not indicated on this particular docket sheet. However, as a matter of law, I'm suggesting that an existing statutory law is necessarily an implicit term of a plea agreement for the purpose of pleading guilty.
You would agree that a defendant can decide unilaterally to plead guilty without reaching an agreement with the Commonwealth?
I don't think I'm willing to concede that, Your Honor. No, that he's in effect pleading guilty with the Commonwealth in order to plead guilty. I think that has to be true.
Are you saying that the Commonwealth can insist on going to trial even if the defendant decides to plead guilty?
No, Your Honor.
So doesn't that necessarily imply that the defendant can decide on his own unilaterally to plead guilty without the agreement of the Commonwealth?
I suppose that is true, Your Honor.
Okay, so what here in the record would show us that that is not what happened?
Well, I think you can infer that from the record where there are, at the time that this was done, this is an OUI 3 guilty plea based on the 2000 OUI and 2 1992 OUIs, but not a 1982 and a 1983 OUI. So I think there's some suggestion, there's an inference there that there's some sort of an agreement that he's pleading to something that would be less than what he might face.
How could those two earlier convictions have been counted?
Actually, they could not have, Your Honor.
Right.
In any event, I'm suggesting that there's sufficient evidence here on the record to suggest a guilty plea, a plea agreement.
Okay, if there was no plea agreement, if the record is insufficient to support that contention,
yes,
what happens then to your argument?
I think it goes away. I cannot make the argument. In that case, though, I think the issue preclusion argument would still survive. Well, no, I think that, again, that necessarily is premised on there being a contract argument. Well, at any rate, may I continue with my plea contract argument?
Absolutely.
Thank you, Your Honor. I'm suggesting that that the year 2000 OUI 3 plea agreement is a contract, that there was a 10-year look-back rule that was an implicit term of that contract as the existing statutory law at the time, that based on that implicit term in the contract, you would count, for the purposes of 2000 and prior OUIs, you would count the 2000 OUI and the two 1992 OUIs. That would go back to 10 years, but that would exclude the 1983 OUI, which is Exhibit 1 in his 2019 subsequent offense case. So that would be controlling law. I'm also suggesting that there has to be an express reserved power in order to change that term in the plea agreement. In other words, to change it so that the 2002 amendment changing the OUI statute to a lifetime look-back rule instead of a 10-year look-back rule, that would have to be an express reserve power in the plea agreement. So for those reasons, I would suggest that for the purpose of that is an enforceable contract right as to the number of OUIs counted for the year 2000 and prior.
So counsel, am I correct that under your argument, a defendant who had the same record as your client of the 2 convictions in the 1980s and the 2 convictions in the 1990s, that a defendant who then did not commit an OUI in 2000 would be in a worse position than your client, right? Because
if he went to trial?
Well, no, if they then committed an OUI in 2011, because they wouldn't have this argument you're making about the contract, they would just have all those prior convictions, right?
I'm not sure if I understand your question. To get to the OUI 5 in this case, you had his conduct in 2011, plus you had the 2000 and earlier OUIs to add as subsequent offenses.
Right, but you're saying that we can't look at the 1982 convictions because your client had an OUI conviction in the year 2000.
That's correct.
Somebody else who had not operated under the influence in the year 2000, you're saying it would be perfectly fine to look at the 1980s conviction.
Oh, on different facts in a different case, you could, depending on whether there was a guilty plea or whether the person went to trial. If there's a guilty plea, I believe that has to be a plea agreement, although that may not be correct. But that would trigger an enforceable contract, whereas if you went to trial, it would not. So you would be in a better position for the purpose of counting subsequent offense prior convictions based on a guilty plea agreement as opposed to going to trial. It doesn't matter what year it's in. It's just whether there was a plea agreement.
And the Commonwealth argues that the OUI subsequent offender convictions are not progressive. What do you say to that?
Prospective?
Progressive. In other words, like that you have this OUI 3, but I think they're saying they're not necessarily building. You don't.
Yes, that's certainly true. I mean, if the lifetime look back rule applies, then you can look back and hit the 1982 or 1983 conviction. Here, they relied on the 1983 conviction plus the 3 from the OUI 3. So that's their 4.
So if the look back period had always been set at life, and for whatever reason in the year 2, and he had these 4 convictions from the 80s and the 90s, but when he had the OUI conviction in the year 2000, but for whatever reason that the Commonwealth proved OUI 3 in the year 2000, do you think collateral estoppel would apply in that case?
Well, I would suggest that that rises or falls with the contract claim, because the Commonwealth correctly cites Sanchez to say that the law has to be identical for there to be issue preclusion. But that in turn depends on whether the contract claim works. If the contract claim is correct, then the same law would be the existing law at the time of the year 2000. It would be the 10-year look-back rule in 2000. That rule would still apply as to 2000 and prior factual determinations of OUI in 2019 at the subsequent offense trial. That would be the same law. If, on the other hand, the lifetime look-back rule applies, as the Commonwealth suggests, then you would not have identity of the applicable law, and the issue preclusion claim would fail. So it rises or falls with the contract claim. I think that is necessarily true. I'd like to point out that Albert A is not a contract analysis. The Commonwealth is suggesting that Albert A and McMullen and the Peter Hurley pro se claim from 2018 addresses the contract issue, and that, but I don't believe it does. I mean, Albert A is not a contract analysis. It was a contention that the plea agreement was involuntary. It's not a contract analysis. It says for the plea to be voluntary, you do not need to inform the defendant of collateral consequences in the form of a possible future change in the law. That's different than a contract analysis. I'm not talking about collateral consequences here. I'm talking about a change in the law as being contradicted by the lack of an express reserved power to change a term in the contract, i.e. the implicit term of the express of the existing statutory law at the time of the earlier plea. I will give you an example of how it can be done in contract analysis, and I have it in my brief. That's the California case of Doe versus Harris. There, the California Supreme Court said that there's a different rule for plea agreements where there is a deemed reserved power to change the law on a public policy rationale because it involves public safety, unlike ordinary contracts. So they have a different rule.
Was there a written contract in that case?
I don't know, Your Honor. I don't know that. But I'm suggesting that would put it into contract analysis. That would be a contract holding as opposed to a involuntary plea agreement type holding, a due process type holding involving collateral consequences.
Is there any reflection in the record here that there was an agreement as to sentence, for example, when he tendered his plea in 2000?
I don't believe so, Your Honor. The only evidence we have of the 2003, the year 2000 plea agreement is that docket sheet. And on pages 52 and 53. That's it. Yes, Your Honor. I'd also like to point out that that isn't even part of the earlier Peter Hurley pro se case from 2018. That had to do with he was challenging his two 1992 convictions on a similar rationale, but it was not spelled out. He didn't spell it out in terms of contract principles. He was just saying that there's a constitutional right to enforce his contract, but that didn't have to do with his 2000 plea agreement, which is the basis of my contention here. So it's a separate factual thing. It's an unfleshed out argument in terms of contract. And I think Albert A is not really a contract holding, so I don't think it really applies here any more than the ex post facto cases or anything like that apply. Unless there are any other questions, I'd like to rely on my brief. Thank you, Your Honors.
Let me check. I think we have your argument, but let me check for questions. No? All right. Thank you, Attorney Maddox. Attorney Semmel?
Thank you.
Morning, Catherine Semmel for the Commonwealth. I'd just like to briefly note that the defendant did file a Moffitt brief after the Commonwealth filed its brief on appeal. The issue raised in the defendant's Moffitt brief was resolved by a prior panel of this court in 2018. concerning the booking video, and the panel at that time found no abuse of discretion in the judge's handling of the matter and imposition of remedial measures in terms of instructions. So that issue has been completely resolved against the defendant in a prior decision of this court. For the contract argument raised by the defendant, there's absolutely no evidence that collateral consequences are generally or were specifically in this case a promise in any plea agreements that were previously reached. McMullen, on which the Commonwealth primarily relies, was a breach of contract claim. Certainly, it specifically ruled that there's a published decision of this court specifically rejected a defendant's argument as to breach of contract for with regard to the enlarged reachback period of this precise statute. I suggest that has been resolved, and the court found in that case that there was no breach of contract. The 2017 unpublished Hurley decision did, as my brother noted, involves precisely the two 1992 OUI convictions, which were two of the prior convictions used in this case. In that case, the defendant did bring, exactly as he does here, a contract claim, arguing there was a breach of contract for those to be used to enhance his subsequent offense because of the enlarged look-back period that had occurred in that intervening time. And the panel in that case rejected that argument. The defendant cites no cases where a Massachusetts court has ever found that collateral consequences are part of a plea agreement as some normal event. And all the cases which are cited by the Commonwealth hold to the contrary.
You just referred to this, Attorney Samuel, as a plea agreement. Does the Commonwealth agree that there was a plea agreement here?
I don't know the circumstances of the plea. I don't think they've been fleshed out, and I'm not personally aware, and I perhaps used that term too loosely. I'm sorry. There was certainly a plea, and I'm afraid that's all we know about it. With regard to the other arguments raised by the defense, as Justice Henry was discussing, the Commonwealth has pointed out that this is not a progressive offense, in that is that you don't need to prove an OUI fourth to get to an OUI fifth. The statutory language clearly requires a proof of 4 prior OUI convictions, which is what occurred in this case, and the defendant doesn't challenge the sufficiency of those. And
what about my question though, counsel, that let's just assume we always had a lifetime look back, but for whatever reason in the year 2000, the Commonwealth had the 4 prior convictions from the 80s and the 90s, but for whatever reason on the 2000 offense, they only proved OUI 3. Okay.
Yes.
Would collateral estoppel apply to prevent them from trying for a higher OUI level with the 2011? Like, could it only be 2000? Could it only be OUI 4, or could they go back and try to prove something different?
I think that because the statute requires the 4 prior convictions, and that's the specific requirement, that the prior OUI third doesn't inhibit or restrain the Commonwealth as to its proofs. I mean, it is used in the inverse, as the defense points out in the Bowden case, that it can be, an OUI third can be sufficient evidence of 2 other prior convictions, but it does not, there's absolutely no authority or suggestion that it should in any case, in any way, preclude the Commonwealth from satisfying the statute, through this specific language.
If the Commonwealth had tried to prove OUI 5 in 2000 and tried to prove all 4 of those convictions, but only got to OUI 3, would there be claim preclusion then?
You mean if the court specifically rejected the proofs as to one of the OUIs? Yes. Is that the scenario? That's a very interesting question, which happily is not my responsibility. But I think in that case, I think the court may be might be faced with addressing something that is just in a footnote in my brief, which is whether collateral estoppel should ever apply in the sentencing enhancement context. And I know there's some states that have said that it just shouldn't, due to the nature of the proofs, that and that you shouldn't apply in that circumstance. But I agree, that would be a different question, Your Honor. Perhaps some other time. I don't really have anything to add to my brief other than those arguments. If the court has no further questions, I'd be happy to rely on my brief.
I think we have your argument. Let me check for questions. Thank you. It's an interesting case. We've been helped by both of your arguments, and the case is submitted. Thank you.
Thank you.
Thank you, Your Honor.
Get going, and I will call the case after we have gone live.
The case is now being recorded.
Good morning and welcome to this session of the Massachusetts Appeals Court, which we are conducting in this format because of the ongoing pandemic. Despite this format, all the ordinary rules of argument apply, including that each side gets 15 minutes to argue with no rebuttal. With that, I'm going to call the case of Commonwealth versus QUINCY Butler, case number 2020-P0149. Attorney Thompson, we're ready whenever you are.
Thank you, Justice Wolohojian. Good morning. May it please the court. My name is John Thompson. I represent QUINCY Butler, and with me off screen is my partner, Linda Thompson, who also represents Mr. Butler. This is a double jeopardy case that comes out of that follows 4 trials on a 2004 first-degree murder indictment for the death of Betsy Tripp. There have been 4 trials, 3 of them completed, 2 of them ended in hung juries, and in June of 2009, Mr. Butler was convicted of second-degree felony murder. He was acquitted of all the first-degree murder theories. The Commonwealth has indicated that it's going to retry him. It wants to retry him on second-degree malice murder. Following the reversal in 2017 of his convictions.
So, counsel, just to set the frame here, so you agree the defendant has the burden of proof, the defendant seeking to dismiss on double jeopardy grounds has the burden of proof, and you think it's by a preponderance of the evidence. Is that right?
That's correct, Justice Henry. I rely on Lego versus Toomey, the Supreme Court case that says that the burden of proof on pretrial issues generally is a preponderance of the evidence. I was unable to find a Massachusetts case that articulates a standard of proof in double jeopardy cases.
And you think that, if I understand you correctly, that you think there are 3 possibilities of what this last jury did, which was 1, an actual acquittal, 2 was no consideration of malice murder at all, and the 3rd was that the jury was undecided. Is that right?
I think that that there's really only one reasonable possibility, Justice Henry, and that is.
I didn't use the qualifier reasonable. I used at all possible.
Well, I think logically, with the unmarked option on second-degree malice murder, it could mean that the jury returned a verdict of not guilty. It could mean that they didn't consider the claim or the issue, and it could mean that they considered it but did not decide it.
Thank you.
Or couldn't reach agreement.
That's right. It couldn't reach agreement. I would take those to be the same. So our case is that we have a circumstantial case that's very strong.
May I ask you before you get to that, what is the standard of review?
The standard of review here, this is an issue of law, so it's de novo.
Is the question of what the jury did, but when it left the verdict slip blank with respect to malice murder, is that a question of law or a question of fact, or a mixed question of law and fact?
I would say it's a mixed question of law and fact. It is it's a question of interpreting evidence. That is, we're looking at the verdict slip, we're looking at the jury instructions, and we're looking at the Supreme Judicial Court's interpretation of the verdicts in Commonwealth versus Wood, which is the appeal of Mr. Butler's co-defendant, Mr. Wood. We're looking at all of those as evidence of what the jury did, and is what the jury intended by not marking the second-degree malice murder option on the verdict slip.
Do we review the factual component of this for clear error?
I think I think the factual component is also de novo. It's all documentary. There's no testimony that underlies the trial judge's or the motion judge's findings. So I think that because it's documentary, this panel is in as good a position to adjudicate the facts as the motion judge was. And I think that under Massachusetts law, in those circumstances, the court looks at the facts de novo as well.
Do you have a case that lays this all out in this particular context?
I'm thinking in the context of suppression, the suppression cases, which the name of the case doesn't come to my mind at this moment. I'd be happy to send a letter to the court on that point following the argument. As I said, we're relying on the jury instructions, the jury verdict form, and the SJC's interpretation as evidence that the jury actually acquitted Mr. Butler of second-degree malice murder. The important thing about, or one important thing about the jury verdict form, the verdict slip, is that it does not provide an opportunity or an option for the jury to actually record all of the verdicts that it was required to render by the jury instructions.
Counsel, could defense counsel have polled the jury at the time the verdict was rendered?
The defense counsel could have asked, either counsel could have asked for a poll of the jury. That is, I think the fact that he did not do that shouldn't count against the defendant at all. And in my brief, I've cited, in my reply brief, I cited a case called Commonwealth versus La Capucia, which speaks directly to that point, but in which the court basically said in a double jeopardy context where there were split verdicts and it was impossible to determine on which indictments the defendant was acquitted and which ones he was convicted, that it's unreasonable to expect that that a lawyer would foresee this problem. That is, that there would be split verdicts, there would be a reversal, and then a double jeopardy problem on retrial. So while that's a possibility that could have been done, I don't think that it should be taken into account or should count against Mr. Butler's claims on the fact that he didn't do that.
So assume with me for the moment that the jury was not able to reach a unanimous verdict on malice murder, that there was in fact disagreement among them. Would they have ended up marking the verdict slip exactly as they did here, or should something else have happened?
Well, the jury wasn't told to do anything if it wasn't given any instruction on how to record an inability to agree. But it was given instructions that directed it to render verdicts, and there's no indication in the record that the jury was unable to agree on that verdict, on that particular option. I would point out that in the judge's instructions, which I think in general are very directive, he followed a formula in describing each decision that the jury, or each verdict that the jury was to render on each of the options. That is, he said, you have to consider all the evidence, you have to compare it to the elements and make a judgment on the elements and the evidence. If you find that the Commonwealth, or if the Commonwealth has proven this option or each of the elements beyond a reasonable doubt, then you should convict. If you find that the Commonwealth has not proved each option, each element beyond a reasonable doubt, you may not convict. So he gave them a choice between conviction and acquittal.
But you can't read that without the instruction that tells them that they need to make that decision unanimously. So it doesn't foreclose. So the absence of the check mark on malice murder doesn't foreclose the possibility that Justice Henry posited, does it?
It does not foreclose that. It leaves that possibility there, but the question is, what does the other evidence tell us about what the jury probably did? That is on a more likely than not standard. And it's pretty clear that, well, first of all, just take the first-degree murder options. The jury was told with the hard transition instruction that it could not consider second-degree murder until it had decided all the first-degree murder theories. That didn't leave an option of a failure to reach a verdict on any of those three options. So the first three blanks or unmarked options on the verdict form are actually verdicts. They're not guilties. Deliberate premeditation, extreme atrocity or cruelty, and felony murder. Then the hard transition instruction tells the jury that they now, after they've actually acquitted on first-degree murder, they look at second-degree murder, and it's very important that, again, they're given the acquit or the conviction or acquittal directions there.
But counsel, some of the cases you rely on are a little bit older. And in 2019, in Commonwealth versus Namick, the Supreme Judicial Court said, and I'm quoting here, that this court repeatedly has declined to accept a jury's failure to mark one of the theories of a charge as an acquittal on that theory. So in light of that most recent case, how could we rule otherwise? How could we rule in your favor?
Well, the point that an unmarked option alone does not operate as an acquittal is not to say that every time that there is an unmarked option, acquittal is not a possibility. We know from the Blackwell case and the Berry case that and from the Roth case and from the Smith case, that unmarked options can still result in acquittals. So, as in Carlino, the unmarked option alone does not operate as an acquittal, but it's still a question of evidence. That is, the unmarked option is not the only evidence we have here. We have the instructions in which the jury on second-degree murder in particular, the judge said, you should consider, well, first of all, he said, he described second-degree malice murder as simply second-degree murder. And he said, the elements here are an intentional and an unlawful killing with malice. And you have to consider those. And if the jury has not, if the Commonwealth has not proved both of those elements beyond a reasonable doubt, you cannot convict on second-degree murder unless you find felony murder. The jury, following those instructions, found felony murder. Now, this takes us to the Zanetti case, which I cited in my reply brief. where the Supreme Judicial Court in 2009 said, we can infer, we will infer, or they put it in the negative, but it allows an inference of intent to acquit where the instructions would lead the jury to believe that a finding of guilty on one offense necessarily implies a finding of not guilty on the other. This is that kind of a situation.
How would this verdict slip look different if the jury had simply disagreed with respect to the theory of second-degree malice murder, as opposed to having reached a unanimous decision to acquit?
I don't know that the verdict slip would look any different. The jury would presumably, or the jury may have, in those circumstances, reported to the judge that they were unable to agree on that.
Why? Because the instructions told the jury that these two theories both needed to be considered, but that they could convict on one or both.
That's correct.
So why would they then report that? What required them to report if that they hadn't put a check mark next to malice murder because they couldn't agree?
I don't think they would be required to report that. I'm saying that that's something they might have done because the instructions that they were given on the element, on each option.
So if we can't foreclose the possibility that the absence of the check mark indicates that the jury simply couldn't agree, couldn't reach a unanimous decision with respect to malice murder, then how is it that you meet your burden to prove that this was an acquittal?
Well, my burden is by preponderance of the evidence. So we don't have to rule out. I'm not required to rule that all out. But the jury here was very attentive and asked a lot of questions, and particularly on this subject. When you look at the Supreme Judicial Court's ruling in the interpretation of the verdicts, they point out that the jury asked the judge when it was considering stepping out of or doing something other than what his instructions told them clearly they could or could not do. They asked the judge when they decided that they were going to hold Butler responsible for less than first-degree murder. They asked the judge whether the joint venture theory prohibited them from taking that step. So if they ran into, if that problem came up, that is, if they were not able to agree on second-degree malice murder, you can logically infer that they would have asked the question. They didn't ask a question about that. They did, though, move on to felony murder and make a decision on felony murder.
Okay, we're going to have to leave it there because your time has expired. Let me see if there are any other questions. No, thank you very much.
Thank you.
Attorney Campbell.
Thank you, Your Honor. Good morning, and may it please the court. Kaylin Campbell on behalf of the Commonwealth. I'd like to first acknowledge the victim, Betsy Tripp's family, who are watching this live cast this morning. We ask you today to affirm the denial of the defendant's motion to dismiss. Very simply, double jeopardy does not bar retrial of the defendant for second-degree malice murder. All of the defendant's arguments are defeated by a careful reading of Carlino and the cases that come post-Carlino and the transcript of the jury instructions. I'd like to point first to a case that my brother brought up in argument, Zanetti. And I think the specific language that they use in Zanetti is important and instructive as to the legal question that must be answered. And I quote, the SJC and Zanetti said, "We will not infer acquittal from silence on a verdict slip unless a conviction of one crime logically excludes guilt of another crime. If it is possible that the jury were split as to the crime for which they gave no indication, double jeopardy does not bar retrial at all. And so all that's required is a possibility on the record that they were split that serves to say that double jeopardy does not bar retrial. My brother has conceded. I counted at least two times. Sure.
First, just to set the frame, do you agree with defense counsel that his burden originally in the motion was to prove by a preponderance of the evidence?
I do.
You do. And do you agree the standard of review is de novo or not?
It's interesting. So I pulled out Carlino where they talk about what standard they're applying, and that can be found on page 78 specifically of Carlino. And Carlino says, and I'm quoting, "We cannot determine from the verdict slip what decision the jury reached on the felony murder theory, except that their verdict cannot be construed as a conviction on that basis. Thus, we must decide whether we are required to treat their silence on the felony murder theory as an acquittal for purposes of double jeopardy." So I would say that they are considering it de novo, right? Because they're looking at the facts as they appear in a documentary way. I'll save my brother a 16L letter. The case that I think he was referring to is Commonwealth v. Tremblay, which can be found at 480 Mass 645. That's a motion to suppress case in which the court was reviewing a recorded statement, and they said because they were in as good as a position as the motion judge to review the recorded statement, that they could make findings based on that statement in the same way. I agree here that there is only documentary support that we're looking at, so I would suggest the same would apply. I would say, though, that I think the way that they frame it in Carlino is important because it's what we have here, really, all you can tell is this silence, right? And as was discussed repeatedly in my brother's argument, there is no indication that it is anything but three possibilities, right? And the possibilities discussed in Carlino. It's acquittal, it's that they couldn't reach a unanimous verdict, or it's that they didn't even reach the verdict at all. I would say that
in this case, if the third one really is a possibility, given the instructions, because and given the verdict slip, which uses the words and or, and the jury instructions require that they must consider both theories.
Correct.
In order to determine whether they're to convict on one or both.
Or both.
And I can't therefore get my head reading those things to the idea that they didn't consider that there's a possibility that they disregarded the instructions, disregarded the and or format of the verdict slip, and just skipped over the first option.
Sure. And even if that is the case, I would point to Sinetti and say that the possibility that they were not unanimous on that theory is enough to say that double jeopardy doesn't bar retrial.
Okay, so you would agree that really the two possibilities we're looking at here are acquittal and lack of agreement. Otherwise, it seems to me the Commonwealth is asking us to conclude that the jury disregarded the instructions and disregarded the structure of the verdict form.
Sure, and I'm not asking that. You know, that is a reasonable interpretation of that instruction. And I'd say for a decision post Carlino and falling in line exactly with Zanetti, that just the possibility that they were not unanimous on it is enough not to bar retrial.
So do you agree, counsel, that if the jury had been polled and it all said, oh, we acquitted on the malice murder theory, that retrial would be barred?
Yes.
So defense counsel says, well, we really shouldn't leave whether this man is retried up to a possible error of defense counsel. And is there any strategic reason why he wouldn't have asked that question?
I mean,
law?
Sure, it hasn't been raised, so I can't. Off the top of my head, I don't know why it wasn't asked, and there could be reasons. I don't want to foreclose the possibility that there could be reasons. I would say that the cases that my brother cites to as to that proposition are older, and I think it's important, as with most of his arguments that relate to lenity, as relate to how the court should view this, that it's important that pre-Carlino, there were SJC cases that indicated that silence could be construed to be acquittal. And so certainly cases that come prior to that, in Carlino, the SJC took the opportunity to refine and explain its holding that going forward, it would not be that way. Either way, I'd say that looking at the record that is before this court, and looking at the burden that would be the defendants to show, and looking at the issues that he does raise, that it certainly indicates that double jeopardy does not bar retrial in this case.
So it seems like and I don't have a record citation, but it seems like the motion judge did in fact find that the record was ambiguous about what the jury did. And if that's the case, why would we not apply the general principle that ambiguities and doubts in criminal law are resolved in favor of the accused?
Sure, and I'd say that you wouldn't, because Carlino and the cases post-Carlino have recognized that where there is that ambiguity and where that is that possibility, that double jeopardy does not serve as a bar to retrial. So I'd say certainly that's an argument that the defendant would be welcome to make before the SJC, but given the current state of the case law, Carlino and Zanetti foreclosed that for an option here.
Why shouldn't the burden be on the Commonwealth to ask to pull the jury?
I'm not, you mean post-verdict as to?
Yes.
You know, there is no obligation currently that the Commonwealth do so. That would certainly be a new obligation that was put on the Commonwealth. I don't think that there is much case law that I've read about the necessity or the reasons why you would poll a jury. I quite frankly don't know legally what reasons one way or the other there would be for that.
I want to ask you a question about potential practical consequences.
Mm-hmm.
As I understand it, the defendant's motion down below was not limited to the second-degree murder conviction, but also sought relief with respect to the other convictions.
It did.
The motion as a whole was denied, but on appeal is only that portion. Well, he's only pressed arguments with respect to the second-degree murder conviction.
Mm-hmm.
If we were to agree with him, what can you explain to me from the Commonwealth's perspective, what would be the practical consequences of such a decision?
The practical consequence would foreclose the Commonwealth from proceeding against the defendant as to second-degree malice murder. As to the other convictions that don't relate to murder, they were returned. There's no question as to what the verdict was, so we could go forward as to those convictions, and certainly nothing sort of legally or in the record would foreclose the Commonwealth from being able to do so. I would highly suggest, as is obvious by the argument that I'm making, that the court do not agree with the defendant based for all the reasons in my brief, but it would not foreclose those other indictments to go forward.
So I guess is it correct that we are interpreting the 3 blanks in the first-degree murder section as acquittals, right?
Yes.
And then you're saying, but let's not treat the blank under second-degree murder, malice murder as an acquittal on that theory, right?
Absolutely, but I think the difference there is found in in how the jury was instructed, right? So if you look at volume 18, page 61, the jury is given that hard transition language, right? If after your consideration of the evidence, you've find the Commonwealth has not proven beyond a reasonable doubt all the elements necessary to prove the defendant guilty of murder in the first degree, you should then consider whether the Commonwealth has proved murder in the second degree. The jury was also told, and this is on volume 18, page 60, that they had an obligation to return the highest degree of murder. So I'd say those in combination give you, if you're looking at it, it's the same theory, right? It gives you the evidence necessary to determine that that silence is not unambiguous. It necessarily means that it had to be an acquittal. That type of language, if you compare and contrast that hard transition language, as it's called, on page 61 with how the jury is instructed specifically as to second degree murder on page 62, they're not given that then language. It says, if you find that he's not guilty of second degree malice murder, they say you have to find him not guilty of second degree murder unless you find him guilty of felony murder. There's not that transition that's put there. There's not an if then, but you also have to look at that in conjunction of the remainder of the arguments, specifically pages 66 through 68, in which the judge walks them through the verdict slip and talks about how you could find the defendant guilty of second degree murder and you have to consider both theories, and you can find one or the other or both. And so I'd say looking at that in conjunction shows sort of on the record why these two silences can be treated differently.
So the defendant points to this language that's at the record, page 60, where the judge says, if, however, after. Now, the after really is before. It says after your consideration of all the evidence. Then it says that the Commonwealth has not proved beyond a reasonable doubt either one or any of these two elements of murder in the second degree. So he's, in other words, the judge is saying, if after looking at the evidence, the Commonwealth hasn't proven malice murder, you must not convict the defendant of murder in the second degree unless. And then he goes, right. So, but that does. So you're saying that's not enough to be a hard transition?
Correct. Correct. Not only is it not enough to be a hard transition, I think I'd have a more difficult argument if you didn't then look, as you have to, at page 68 with how he walks them through the verdict slip. And I think that's important too, because if you look at how the SJC looked at the verdict slip in Carlino, they go through the instruction as to how the judge instructed them as to the verdict slip specifically. And that makes sense, right? Because if you're wondering how a jury filled out a verdict slip, looking at the instructions as to how the judge specifically instructed them as to the verdict slip is really sort of the best place that you can look. And there, logically, if the defendant's sort of construction of what this argument meant, they wouldn't have been told they could have checked off both theories of murder, right? Because once they reached second degree malice murder, they wouldn't have had to go on and consider second degree felony murder. So that sort of construction is defeated by the instruction that's contained on page 68. I see I have 59 seconds left, so if the panel has no further questions, I'll rest on my brief.
Let me check. All right, seeing none. Thank you both for your arguments. It's an interesting case, and we were aided by both sides' arguments.
It'll be a moment.
Thank you.
The case is now being recorded.
Good morning and welcome to this sitting of the Massachusetts Appeals Court. The panel today is Justice Henry, Justice Singh, and myself, Gabrielle Wolohojian. We are conducting this argument in this format because of the ongoing pandemic. Despite using this format, all the ordinary rules of appellate argument apply, including that each side gets 15 minutes to argue with no rebuttal. With that, I'll call the following case of Diplomat Property Manager versus Crystal Heims, case number 2020P0239. Mr. Wasser, we're available.
Yes, Justice.
We're ready whenever you are.
Thank you, Justice Wolohojian. Panel members. In 2012, the Lozanos were denied a loan modification on the grounds that their loan had been paid off and not by the Lozanos. And this story persisted for years, and Lozano's were never granted a loan modification. Consistent with that story, in 2015, United Guarantee, a private mortgage insurer subrogated to the rights of the first mortgage holder, filed the first lawsuit against Lozano seeking a deficiency judgment due to insufficient proceeds to pay off the first mortgage note following the foreclosure of the first mortgage. That first lawsuit led to a settlement and release agreement for all claims against the Lozano's home, discharging all liens, and included a defense and indemnification benefit to the Lozanos. So at this point, the Lozanos should reasonably have been expected to keep their home, either based on the wrongfully denied loan modification or the settlement and release agreement. But instead, United Guarantee breached their agreement and changed their story to say that they were the private mortgage insurer only for the second mortgage, which makes no sense because PMI only insures first mortgages and doesn't even apply to second mortgages.
Okay, what does all of that have to do with the anti-SLAPP motion?
This is because we filed a plenary action in the Superior Court to prevent all of these different separate actions that Diplomat and its predecessors were filing against my clients. We're here today on a case brought by Diplomat that's the sixth lawsuit in a six lawsuit saga. And Diplomat, by Rule of Procedure 12B9, also by a stipulated judgment and by contract law, was supposed to be required to assert its claims for possession in the Superior Court and is not even supposed to be allowed to harass the Lozanos by filing this duplicate lawsuit in the housing court.
But again, the question is whether you satisfied the requirements of the anti-SLAPP statute, which has its own requirements. So it might be helpful if you began with that, because as I understand it, what we've got here is an interlocutory appeal from the denial of your motion, your special motion to dismiss on anti-SLAPP grounds. Is that correct?
Yes, Your Honor. So the first stage, based on rule under the anti-SLAPP statute. Sorry, go ahead, Your Honor.
I was going to say, I noticed that in your brief, you really rely almost exclusively on the Durcraft framework, but the Durcraft framework has been modified subsequently by Blanchard.
Correct.
So it's, I think, helpful to use the Blanchard articulation of the form of the framework.
Sure, Your Honor. So we have basically the separate structures. We have to still establish the baseline rule, which, from my reading of the opposition brief, that seems to be, their main argument is where they focus. And so, importantly, Diplomat makes much ado about whether it was aware of the prior pending fourth lawsuit, a sixth lawsuit. But this is at best an issue of fact and a red herring, because regardless of what Diplomat knew when it filed the sixth lawsuit on May 15, 2019, as the record reveals on pages 75 and 76 of the record appendix, Diplomat was placed on actual notice of the prior pending refiled fourth lawsuit on May 22nd, 2019, only a few days later. The anti-SLAPP statute says nothing about state of mind at the time of initial filing, and it would have little meaning if parties could get away with strategic litigation against public participation if all they had to do was claim ignorance at the time of the initial filing of it.
I think the law says that motivation doesn't matter for the first step of the framework. The first step of the framework is whether the complaint is based solely on petitioning activity.
And
so here, the complaint at issue, as you correctly noted, is the summary process complaint.
Yes, Your Honor.
And we don't look to motivation. We look instead to the claim itself to determine whether it's based solely on petitioning activity. Now, this is an action seeking possession of the property.
Correct.
For what? Why? On what ground did the plaintiff seek possession? What did the complaint say?
The plaintiff was seeking possession based on its purchase of a quitclaim deed from a party who purchased its quitclaim deed from a party that purchased a foreclosure deed at a foreclosure. So they're like three titles removed.
So basically it's claiming it had superior right to possession of the property.
That's correct.
All right,
But-
so how is it that that complaint is based, quote, solely on petitioning activity, given what it alleges it's based on?
Well, first of all, I'm not entirely sure that motivation doesn't play a role in, because the motivation tells you why it's based on it. And so what happened here was, when we know that Diplomat's refusal to dismiss the 6th lawsuit was based on the Lozano's petitioning activities, because it admitted that part of its motivation for filing the lawsuit was
It's not based on, it needs to be solely based on.
it was solely based on it because it was not happy with how long it would take for this matter to be litigated through the Superior Court Department. And page 78 of the record appendix, there's an email from Diplomat's counsel saying that they're frustrating and they don't want to wait for the resolution that would occur in the Superior Court.
Maybe there's another way that I can ask this. Can anyone get possession of a property because you're frustrated by how long it's taking to use some other route?
No, we have a prior pending action that Diplomat themselves filed a counterclaim for possession. That's happening in the Superior Court. So regardless of the underlying merits of the case, Diplomat, nobody can file a duplicate action and have a justifiable reason for it. They can't say that they did it just to get possession, because they already have that action going. They could, what if they filed 10 lawsuits all with the same complaint? And on the 10th lawsuit, they could say, no, we just filed it to get possession. There's another reason why they filed this lawsuit, and it was based on the petitioning activities of the Lozanos, sorry, Your Honors, based on the petitioning activity of the Lozanos in filing the complaint in the 4th lawsuit in the Superior Court.
Okay, so you're saying the petitioning activity was the Superior Court suit?
That's correct.
All right,
And
so could you bring a summary process action saying someone filed suit against me in Superior Court, therefore I'm entitled to summary possession of the property?
Yes, you can bring a claim for possession in the Superior Court. It's a
But
common
the
law.
basis for that claim could not be that they filed a claim somewhere else. That is not what would entitle you to possession, right?
Right.
The only thing that's going to entitle you to possession is if you have a superior right to possession.
That's right.
Right,
But-
nothing, it has nothing to do with whether or not someone filed suit anywhere else.
It does when this, so the suit that they're filing, Diplomat's retaliatory action is filing it in a housing court after they already agreed to have their claims heard in the Superior Court by stipulation and by a court order, and where what they're trying to avoid and what they're retaliating against, it's not the possession claim in the Superior Court, it's all of the other claims, because my client is petitioning the court for redress against other parties where claims are superior to Diplomats both in time and in superiority. So if my clients prevail against United Guarantee on the release claim, that discharges the underlying note that Diplomat's title ultimately relies upon, because Diplomat's chain of title, there's a source title in there that's a foreclosure deed. And so if that note was discharged long before, that would undermine the foreclosure suit. They're also retaliating against my client for filing a suit against Christiana Trust. If my client's claims against Christiana Trust prevail, that also would undermine Diplomat's position. So Diplomat doesn't want to.
Counsel, so if the summary process action proceeds and Diplomat wins, but then you prevail against one of these other parties, what happens?
Well, that should undermine Diplomat's judgment. On Chapter 239, Section 7 says that summary process judgments are not a bar to later action or other subsequent action seeking recovery. But the problem we're going to keep running into with this duplicate litigation, which is improper on its face, you can't have duplicate litigation, is now they're going to be arguing res judicata effect in the Superior Court and continuing to try to interfere with our due process rights. As it is, we're getting forestalled to try to get discovery and to try to get these matters resolved. The first thing that normally would happen if this was logical and courts are operating as we would expect, is we would not be putting the cart before the horse and doing Diplomat first. We would be doing UGRIC's claim first and dealing with that settlement and release agreement that has a defense benefit and an indemnification benefit. Diplomat
Okay,
is.
so going back to understand, you're saying that Diplomat was on actual notice of the Barnstable action because it was on the public record?
No, because, well, that too, but on May 22nd, I sent them an email and attached to that email copies of both dockets from both cases, their 6th lawsuit and our refiled 4th lawsuit.
But they had already filed their the summary process action?
No, the Barnstable action was a prior pending action that was filed first by about a week.
But I'm asking, when you sent your email, had they already filed the summary process action?
Yes.
So is there any?
What do you, go ahead.
No, you go.
Can you point to us in the record? I think this is the same question, by page, any place that you can show that they were on actual notice of the your refiled lawsuit before they filed the summary process action?
Yes, pages 75 and 76 of the record appendix.
Okay, let's
It's
look
a
at
copy
that.
of the email dated May 22nd, 2019.
Okay, but that's after they
Okay.
filed the summary process action. I asked for something before. Do you have a page number
Oh,
for?
no, so this is important. Yeah.
Well, it's just a
No,
page number.
what we had.
Do you have a, I take it your
No.
answer to my question is no. Okay.
Yeah, so the answer is no. And so this is an important issue because Diplomat knows what's going on. They're aware of the situation. So what happened is we filed the Middlesex, the 4th lawsuit originally in the Middlesex court. And when that was dismissed without prejudice because there was no records of service on file, even though all the parties knew that service of process had occurred, Diplomat had a contractual obligation by their stipulation to act in good faith and communicate
Counsel,
with us.
I don't understand that argument because the
Mhm.
stipulation to dismiss, which is at page A51, is that they're dismissing a Worcester division case to litigate in Middlesex Superior Court. Why is that an agreement to litigate in a different Superior Court?
Well, you know, the true object of at the time in question, this issue didn't occur. It didn't exist. So we only had the Middlesex court to refer to. So at the time, the agreement, though, the intention of the parties was because we had multiple parties, indispensable parties. I mean, I filed a Rule 19 motion to dismiss in this case, but because we had multiple parties, the agreement was to sequester all the interested parties into one plenary action in the Superior Court, because the Superior Court, A, has jurisdiction over all these cases, and because we would avail of all the discovery devices in the Superior Court. We can't even get discovery against these indispensable parties in the 6th lawsuit. And that's part of what the damage is being done, is they're racing ahead with their judgment. We can't, and when we ask even for Diplomat for discovery, they object and say, well, we're not Christiana Trust, so we can't answer that.
So if Diplomat had in fact filed its summary process action before you filed the Barnstable action, could you have brought your special motion to dismiss?
I'm not sure about that. I do know that at a minimum, it would certainly have been, it seemed to be in violation of the stipulation and the order, because, you know, they should act in good. They're obligated, it's not just our claims. Diplomat's obligated to bring its claims in that Middlesex Superior Court. So in good faith obligation to any contract, and because of the court order, they could have not been silent and tried to pull this little, you know, shenanigan, but they could have reached out to us, act in good faith, and just had the dismissal vacated and shown the Middlesex court this stipulation, and that Diplomat had to assert its claims for possession in that court. And in fact, they could still do it. This court could order. If that docket number in that venue is somehow so important, this court could order that case then be reopened and everything transferred to the Middlesex Superior Court. But I didn't see a practical distinction there.
I want to make sure I'm just clear. What's before us is your special motion to dismiss on anti-SLAPP grounds, correct?
Correct, Your Honor.
That's the only thing.
Yes, Your Honor.
All right, let me see if there are any other questions. I don't see any. Thank you very much. I think we have your argument. Attorney Kingston.
Good morning. May it please the court. Christine Kingston on behalf of the appellee Diplomat Property Manager, LLC. In a 2019 decision about the anti-SLAPP statute, the Supreme Judicial Court in 477 Harrison LLC v. Jace Boston LLC cautioned against the weaponization of the anti-SLAPP statute. In other words, the use of the statute offensively to forestall or chill the valid claims of the non-moving party. And this appeal presents the exact circumstance that the Supreme Judicial Court was warning about in that case. There was no abuse of discretion and no error of law in the housing court denying the defendant's special motion to dismiss. And I want to start, we do think there are two procedural roadblocks to the special motion to dismiss, but I want to start with the merits just very briefly, because I think that's where this appeal clearly fails. The first issue is whether the preemptive filing of the Barnstable Superior Court case even qualifies as petitioning activity. And if the court looks at the letter of the statute, then it could conclude that it does. But I think the Supreme Judicial Court tells us in Durcraft v. Holmes that we should apply a measure of common sense. And the court actually says dueling proceedings between competitors, that's not really petitioning activity, even if it falls within the letter of the law. Even assuming this preemptive filing was legitimate petitioning activity, of course, the defendants have the burden to show that our summary process case was based solely on the filing of the Barnstable Superior Court case. That's where the defendant's motion completely stumbles out of the gate, because first, it's undisputed, despite what my brother has said here today, it's undisputed that neither Diplomat nor my firm as Diplomat's counsel had any knowledge of the Barnstable Superior Court case.
I think his response to that would be, well, it was in the public record, so you were on notice. So what do you say to that?
I think that would be impose a completely unreasonable standard on attorneys to basically monitor every public docket in the Commonwealth of Massachusetts. And the context was, we're coming off a case in the Middlesex Superior Court, which we gave the courtesy to defendant's counsel, and we said, fine, we'll dismiss this prior eviction case without prejudice. We'll let you have at it in the Middlesex Superior Court. And he just simply didn't, he failed to prove valid service. So that's dismissed. And we did, as the record bears out, I believe it's the emails, page 75 and 78 of the record appendix. You can see that we continue to monitor that docket to see if it would be refiled, if he was going to try to reopen that case. And I think we monitored it for at least a few weeks. Nothing happened. So at that point, it was safe to say, this case is closed. We've given you your chance. We're going to move forward with a summary process case, as is our right. And we would have had no way of knowing that he would then refile in Barnstable Superior Court. This is a Upton condominium in Worcester County. It makes no sense that this type of lawsuit contesting the foreclosure on an Upton property would be filed in Barnstable County. In fact, in that pending Barnstable County case, two different judges have asked the Lozano's counsel, why is this pending here? This is an Upton property, and defense counsel has never provided a satisfactory answer. So I would reject any notion that we're required to be on, constructive notice. But I think that the larger point is we simply didn't know. It's undisputed. At the hearing in the trial court, Attorney Wasser concedes, I don't have any information to suggest that they knew. That's record appendix page 162, where that appears in the record. So from our viewpoint, it's undisputed we didn't know, and therefore, as it's necessary fact that the filing of our summary process case could not possibly be based on something we didn't even know about. But even if you take the lack of knowledge out of it, the fact of the matter is the reason the summary process case was filed, the sole reason, not just the substantial basis, but the sole reason it was filed is because the Lozanos continue to hold over unlawfully in this property after 2016 foreclosure and after the property has been deeded to my client, Diplomat Property Manager. And as a result, they're also liable for use and occupancy damages. Chapter 239, Section 1 gives us the right to file this case. It confers standing on us to file it, and that's the reason we did. The court can also take judicial notice of the fact that since we've submitted our briefs in this appeal, the court has actually entered judgment in favor of my client Diplomat, not only on the claim for possession, but also for damages. And so Judge Winnick issued a very lengthy summary judgment decision and then entered judgment. So not only did we have obviously a good faith basis to bring this case that had nothing to do with the filing of the preemptive case, but we've now prevailed on the merits. And my brother briefly—
So the summary process action was not stayed pending this appeal?
No, so Attorney Wasser filed a request to stay in the housing court, which was denied by first Justice Horan, and then he also filed a request in this court, which was denied by a single justice. I believe it was Judge Lemire. It's referenced in my brief. I apologize that I don't recall, but both of those requests were denied on the basis that although you have a right to an interlocutory appeal, you do not have a right to stay the proceedings in the trial court while you pursue that interlocutory appeal. And that's part of the weaponization that that the court, I think the Supreme Judicial Court, cautioned against. I note that this wasn't an anti-SLAPP motion that was brought immediately or even soon after the filing of the summary process complaint. It took 78 days for the defendants to file this motion, and even then it was buried within a 3-part motion raising a 12b9 defense, a jurisdictional defense, and it was clear at that point this is just another arrow in the defendant's quiver, and there wasn't a legitimate concern that this was a SLAPP suit, and so this was brought 78 days later. And so I think that the objective was either if you don't get dismissal, then you try, if it's denied, which it was here, then you try to stay the eviction case, which the defendants did.
Has that judgment been appealed?
Yes, the judgment has been appealed. An appeal bond order has been entered, and that's going to be heard on review by a single justice of the appeals court pursuant to Chapter 239, Section 5, but that hasn't been scheduled yet.
The bond, but there's the appeal on the merits of that has been entered in our court?
It hasn't been entered yet because we're still going through the appeal bond process. So that will probably take at least, I would suspect, another month or so. And that's my concern. In summary, the summary process scheme is designed by statute to be expeditious and to be efficient and to be quick and inexpensive. And the concern is that, and I think the record bears out, there's not a legitimate concern here that an eviction case against people who are occupying a property unlawfully is a SLAPP suit. It's just, I don't think there's a valid concern there. And so for a defendant to deploy the special motion to dismiss, and now we have multiplied the proceedings, we're here before the court, that's a substantial amount of time and resources. And there was also an attempt to forestall the eviction case. And so I think that's what the Supreme Judicial Court is talking about when it says we don't want to see the weaponization of the anti-SLAPP statute. And I think in one prior case it said we don't want this to be used as a cudgel, as a weapon against legitimate claims. And that's exactly what's happening here, is that this was not
arguing. I think here you're arguing the second stage of the inquiry, right?
The Durcraft framework?
Yeah, or well, as modified by Blanchard.
Well, I don't think it ever gets past the threshold showing, because under Durcraft and as modified by Blanchard, the first step is that the defendants have to show it's solely based on the petitioning activities. And I don't think they've ever come close to making that standard. So I don't think we need to get to the second step, which would be the burden shifting to us under the first.
All the arguments you're making about weaponizing and delay and et cetera, seem to me to go to the second stage, which has to do with where you can consider motivation or why the claim was brought, why this claim was brought.
So
but are you arguing those instead as part of the first stage?
Yeah, so the reason I bring up weaponization, Your Honor, is because I think that there needs to be consequences for a party who deploys a special motion to dismiss strategically and in a way that the statute was not designed. And this is pursuant to our request for fees under Rule 25. So I don't think it's relevant to the Durcraft-Blanchard framework, and I'm not arguing it in that context. But I think if the court looks at this motion, looks at the context of the cases, I think that the court can reasonably conclude that this was used in a weaponized manner. And so that's why we're requesting our fees on appeal. And because I do think under the anti-SLAPP statute, if a special movement prevails, they can get their fees. If a special motion to dismiss is deployed strategically and improperly, there's no recourse under the statute itself. And I think this is going to be an issue going forward. And I think particularly in a summary process case when it's supposed to be quick and efficient and inexpensive. And here we are arguing an interlocutory appeal, that I think there needs to be a deterrent. That if you're going to bring a special motion to dismiss, it should be brought within the 60-day time period prescribed by the statute, and there should be a good faith basis to bring it. But on the merits, Your Honor, I do think it begins and ends with the threshold showing, which the defendants didn't make. It's their burden on appeal to show abuse of discretion or error of law. I just briefly want to touch on the procedural issues just very quickly. As I mentioned, we don't think that this motion was timely. We also think that the defendants waived this defense by filing an answer, serving discovery, and filing 2 pleadings. The whole purpose of the statute is to have this heard as quickly as possible. And that simply didn't happen here. I don't, because I think this appeal fails in the merits, I don't think the court need reach this issue, but we've also raised the issue of whether summary process claims fall under civil claims as mentioned in the anti-SLAPP statute. So I did want to flag that because I think that's eventually will be an issue that's decided, but perhaps not necessarily in this appeal. Just in conclusion, Your Honor, Your Honors, I think that I just want to raise the issue of this occurring in a summary process case. And what my brother's argument, I think, is he wants to turn this into a literal race to the courthouse. And that if a prospective summary process defendant understands that an eviction case will be filed, which they frequently will have advance notice of because you have to, in most cases, serve a notice to quit before you bring the complaint. If they just race to a courthouse and file a complaint first, they somehow will be immune from the subsequent summary process case that was coming all along. That's just not the law of the Commonwealth. That's not what the statutory summary process scheme was designed to do. And I think
in this case, had a notice to quit been filed just prior to the parties filing the Barnstable action?
There was not a new notice to quit served in connection with this eviction case because
in that sense, they weren't racing to the courthouse here.
Well, I think that certainly the court can look at the record and the context and make the reasonable inference that the defendants knew the summary process case was about to be filed. And I think that's certainly what happened. And I think that the record does bear that out. Twice we were about to file a summary process case and twice a Superior Court case was filed.
So what about his argument that basically your client agreed to litigate in Superior Court? We could say, potato, or tomato, Middlesex, tomato, Barnstable, but his general argument is that you agreed to the Superior Court litigation. What do you say to that?
Yeah, I think that argument is just completely belied by the plain terms of the stipulation. It counseled on both sides. We carefully worded this. It clearly says dismissed without prejudice to litigate in the Middlesex Superior Court. And I completely disagree with Attorney Wasser that there was any behind the scenes agreement that this would all be litigated in the Superior Court. All along, of course, it was our right and opportunity to file this pursuant to the summary process procedure. And that stipulation, a copy of it appears at pages 95 through 96 of the record appendix. If there are no further questions, I'm otherwise happy to rest on my brief, and I thank the court for your time.
Let me check for questions. I don't see any. Otherwise, thank you both for your arguments. It's been very helpful to us. And with that, the case is submitted. Go live.
I'll let you know when we're recording.
I'm wondering if Attorney Click is frozen.
Your Honor, I don't appear to be frozen from my side.
Oh, great. Nope, it woke up. Great.
Okay.
The case is now being recorded.
Okay.
Good morning. Welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format because of the ongoing pandemic. Although we are conducting argument in this way, the ordinary rules of appellate argument in our courtroom, as though it were live, apply. And that includes that each side gets 15 minutes to argue with no rebuttal. With that, I'm going to call the case of Perimeter Brand Packaging LLC versus 318 Post Road LLC, case number 2020P0208. Attorney Click, we are ready whenever you are.
Thank you, Your Honor, and thank you, members of the board. Attorney David Click on behalf of the defendant appellant, 318 Post Road LLC, in regards to this appeal in part of the trial court's decision in this case, in which a 5-day trial was held in relation to a commercial lease dispute between the two parties. The subject matter of this appeal is with regards more specifically to the misinterpretation and misapplication of the Section 22.04 cost of collections provision of the lease, coupled with its failure to enforce the provisions set forth in Section 6.06 late payment of rent of the lease. In light of the court's order that has not on appeal, modifying the parties' terms in the lease as it related to Section 25.02, which is the notices and communications and how the parties would communicate with each other in terms of formal correspondence. Before getting into the post decision portion of this case, I'd like to just give some background for the court's benefit to establish and give a broader picture as to why it made sense to bring this appeal. The parties enter into this commercial lease between May 2009 up until August of 2015. The initial years of the lease were very straightforward, and there were no issues.
So, counsel, I'm going to interrupt you because we've read the briefs and we're very familiar with the materials, and I have several questions that we won't get to if we go into a long recitation of the facts. You argue in your brief, or you seem to be seeking an additional $17,916.64 in the damages. I'm leaving aside late fees and attorney's fees for the moment. Is that right?
Yes, Your Honor, that's correct.
And
just based off.
Because I don't see in the brief where you explain the basis for that amount. I think I've figured it out, but if it's somewhere set forth clearly in the brief, please point me to that.
Yes, Your Honor. So during, and it's actually, it is shown in page A5 and A6. So that was attached to the actual brief of the appellants, which those are chalks in which the manager of Post Road LLC, 318 Post Road LLC, had testified to in support of the amounts that were due and owing.
So what I understood from that was that you were arguing the tenant owed the 2013 and 2014 CAM charges, late fees for June 2015 rent, and the July and August 2015 rent, and late fees, but I was unclear if those were compounded through August 2015. And from that, you get a total of $39,611.64, so then that breaks down to $26,921.82 in fees of the CAM and the rent, and then $12,689.82 in late fees. Is that right?
Yes, Your Honor, that's correct.
And if I subtract from that the security deposit and the check for $4,065.42, I come up with a number of $13,851.22, but you don't seem to account for the $4,065.
Your Honor, which was going to be a topic of my argument today in going back. So I'm not going to argue against that amount, bringing down what was initially the $17,916.64.
Okay, and then go ahead, Judge Wolohojian.
No, go right ahead, Justice Henry, finish.
So are the late fees there of the $12,689.82, are those compounded monthly, or is that just one set of late fees?
That is one set of late fees. That's compounded. I apologize. That is compounded. So the initial damages that were requested or sought at the point that the perimeter brand packaging had, in essence, filed their complaint for the breach of covenant of quiet enjoyment, breach of the contract to the prior agreement to withhold from collecting on the 2013 CAM charges and the late fee for rent. After that breach had occurred, then 318 Post Road sought all of the actual charges for the 2013 CAM, 2014 CAM, the late fee for the June 1st, 2015 rent, and then the rent due for July of 2015 and the August of 2015. And then that was compounded. So you have the amount of $26,921.82. But then given the fact of the period of time up to August of 2015, that's where that amount of the $12,689.82 comes from. Compounded.
So your position is that the late fee is assessed every single month?
That is my position, Your Honor, yes.
And how does the amount you're seeking now on appeal relate to the amount you sought in paragraph 26 in your counterclaim?
Your Honor, if I may.
I'm looking at record appendix page 22.
Yes,
No,
Your Honor. And
2024.
And that would be based off of a compounding interest for late fee of that payment between essentially September 1st, 2015 to October 1st, 2018, which was the date of trial.
Why is the judge required to, in what way did how can we say that the judge erred in not awarding damages that you did not seek in your complaint?
Well, Your Honor, because it was compounding. And so at the time of trial, bringing forward, it was still a live issue as the total amount, because at that point, issue,
was it a preserved issue? Did you argue compounding to the judge below? And yes. Where will we find that in the record?
Well, the argument came up as to when the demand for the amounts and the late fees had come due. And the manager of 318 Post Road had confirmed that at the time that he made the demand, it was when he actually filed his counterclaims and served the plaintiff and the appellee here with the complaint, because based on the premise that the lease did not state that the landlord could not seek their liquidated damages under section 6.06 retroactively.
Okay,
so there was still a live issue and still compounding given the verbiage of and the reading of 6.06.
I have some questions about the contract itself. I take it that the contract was drafted by the landlord?
It was, and although it was also extended. So initially it had it had started on May of 2009, was set to expire in August of 2014. It was then extended to.
Okay, but was there any drafting of the paragraph 22 that was done by the plaintiff, by the tenant?
It was a lease that was provided to the tenant to review and to report back.
But they didn't make any changes to paragraph 22. At least the record doesn't show that. There's
nothing in the record that shows that, Your Honor.
Okay. So looking at paragraph 22 and the one in particular that you're relying on, which is I think 22.04. And I just want to get to that page, if I may, of the record. What I see here, do you have the page off the top of your head? I'm very sorry.
Your Honor, it's
Yes, I'm on
Appendix
77.
80.
Yep, I'm on page 75 of the, no, 77 of the record appendix. Starting in the sort of throughout paragraph, Article 22, I notice several places where the phrase event of default is capitalized, has initial capitalization. That's in 2201, several places. And then when we get to, and it's also appears in subsections after 2204. But when we are in section 2204, oh, and before I get to that part of my question, I should mention that event of default is a defined term under the contract at the beginning. And it's used actually in various places through the lease. And whenever it is, it's always with an initial capitalization. But here in 2204, it's not capitalized. It's instead used as part of a phrase that says, in the event of default under, it doesn't capitalize cost of collection. It says in any event of default provided for in Article 11. It doesn't use the defined term. Why is this not fatal to your argument as to the interpretation of this provision?
Your Honor, as included in my brief, I'm not, I would concur with the court that arguably this portion of the lease could be considered confusing. And this is why it was a section of the at trial that had been reviewed a number of times. Essentially,
why is it confusing? It just doesn't use the defined term, and yet now you're trying to incorporate the defined term into the cost of collection paragraph.
As it relates to the cost of collection paragraph, that paragraph, it considers, in my position, it considers all events in which there could potentially be a default, whether it would be under Article.
Oh no, but that cannot, I mean, with all due respect, that can't be correct because there is a defined term, event of default.
And Your Honor, I can't speak to why at the time that they had drafted this this portion or this section, why the E on event and D was not capitalized. Just speaking as to how.
I'll just tell you, throughout this provision, there are many places where event of default, the defined term, is used, and it makes sense, and it never is followed by reference to a different article number, because event of default is defined as a default in cases of non-payment of rent. So the easy thing to have done, if this were the intention of the parties, would have simply been to use the defined phrase event of default in the cost of collection paragraph, but that was not done. Instead, they used a different phrase. Why does that create an ambiguity as opposed to just being a choice?
Nowhere in article.
A choice that's good for your client, but it was a choice.
I would submit, Your Honor, that nowhere in Article 11 does it consider rent as an issue, and as it relates to cost of collection. It does identify that in the event that there are expenses incurred by the landlord for removing the lien, that would be considered actually an additional rent. But outside of that, Article 11 leaves wide open any other remedies that are open to the landlord. And in this particular,
right, so they could have provided, but I don't see it. They could have provided in the contract that in the event of default, using the defined term, the tenant will be liable for attorney's fees, et cetera, cost of collection. But I don't see any language that says that in the agreement. Do you?
I just see in the cost of collection phrase where it provides the option outside of, in my reading, outside of Article 11, in the event that the landlord incurs other expenses in the collection of rent and additional rent payments. Not that Article 11 considers rent and additional rent payments, which is why there is a divide between what Article 11 strictly mechanics liens section of the lease and this portion of the cost of collection section, which just involves rent and additional rent payments.
So is your position that this reference to Article 11 in paragraph 22.04 is patently on its face a mistake because it's nonsensical?
It is arguably confusing, Your Honor, yes, and that a review of Article 11 will, and just in view of the Wunsch v. Donnelly case, which was referenced to 1939 case, which is still good law, which was with regards to the interpretation of a lease and whether or not it was considered void for failure to meet a condition. The court in that case just identified that in interpreting the lease, the construction of a lease depends on the intention of the parties to be ascertained by considering all of its terms, giving to the words used the natural and reasonable meaning in light of the facts to which they apply and the circumstances to which they are used. And so based on that premise, Your Honor, I would request that in review of the cost of collection clause that, although arguably confusing, does anticipate and consider payments for attorney's fees in relation to collection for rent and additional rent payments mutually exclusive from collection for dissolving liens pursuant to Article 11 of the lease.
So counsel, did any event of default provided for in Article 11 occur?
No, Your Honor, did not. Not with regards to this case.
And is there
Article 11 specifically?
Is there any, can you point me to a page in the record where the landlord made a written demand for these compounding late fees?
I apologize, Your Honor. I didn't hear the last portion of that.
I see there are written demands for the first late fee, but is there anything in the record that documents a written demand for a compounding late fee?
And Your Honor, that portion of the argument is two-tiered. First, it was based off of the verbiage of the notices of communication in which the notices and demands would be delivered either by hand or sent by certified mail. At trial, the manager of the appellant had testified that he believed that once he had served the complaint, that was the demand for all of these late fees, and it didn't. And the lease in and of itself, the verbiage in which the parties agreed to, didn't bar him or bar the appellant from seeking those fees, late fees, and the charges for CAM retroactively, coupled with the fact that the lease was modified by, as was confirmed by the trial court, by the acts of the parties, and would submit that although the court had identified that the communications or the agreement had been modified because they were transmitting invoices and payments for rent and for late fees by well, it was email in the record, although the court had identified as first class mail, that it's the position that the demand had been modified as well. And
okay, we're going to have to leave it there. I take it that the answer to Justice Henry's, your time has expired. I take it that your answer to Justice Henry's question is no. There's no point in the record where she will find a written demand for the compounded fees.
No, Your Honor.
That's right. Okay. Are there any more questions? Thank you. We'll hear from Attorney Duffy now. You're on mute.
I apologize, Your Honor. May it please the court, I'm Peter Duffy. Good afternoon. I represent Perimeter Brand Packaging, the appellee. I'll just jump right into the issues. On the first issue of whether Perimeter is entitled to attorney's fees and costs, case law in Massachusetts takes a restrictive view of the right of a successful litigant to recover counsel fees. Massachusetts applies the American rule. And the basic rule is that each litigant bears his or her own fees and expenses, except when there's a statute, there's a contract or stipulation of the parties. So here the allegation.
If section 22.04 of the lease is limited to mechanics liens, why does it mention gift?
Why does it mention, I apologize, Your Honor, I didn't catch that.
Rent.
Rent. Well, first off, it could be rent or additional rent. And if you go to the beginning of the lease, there's actually a definition of rent and additional rent, two definitions. Certainly the definition of additional rent would include when the landlord needs to incur expenses because of a breach of the lease. That's encompassed within the definition at the outset of the lease. So certainly the clause makes sense in the context of additional rent. The provision as drafted clearly requires that there be an event of default as provided in section 11. You could conceive of a circumstance where there's an event of default as provided in section 11, and then subsequently rent becomes due or additional rent becomes due. That would be a consistent application of this provision to say that upon the breach of the mechanics lien provision, these other provisions are triggered. And if there were a failure to pay rent following the breach of the mechanics lien provision, then there'd be an argument that there could be a cost of collection in that circumstance. So I don't think that the inclusion of the word rent actually creates any ambiguity here. There's certainly a way that this can be applied on the face of the language that is consistent with it using the word rent as well as additional rent. There's certainly no problem with the use of the word additional rent because the definition of additional rent would include circumstances where landlord incurs expenses because of a breach. And it does make sense that actually there was a concern about mechanics liens at the time that this lease was drafted because there was a build out of the property. And actually Her Honor, the trial judge in entering her findings references the build out of the property and the construction of the windows and that it was done in the tenant specific way. So there's certainly a basis in the record to believe that there may have been a particular concern about mechanics liens in the context of this lease that would give rise to a provision such as this. But in any event, I don't believe that there's any ambiguity in the language in the event of a default provided for in section 11. That clearly is referencing section 11. I know there were arguments made in the brief about the placement of this provision at the end of the lease, and somehow that would indicate that it applies to the entire lease. I would submit that an opposite interpretation is warranted. And to me, it suggests the opposite. The placement of this provision at the end of the lease is specifically why it was necessary to give specific reference backwards in the lease to what provision it applies to. And here it applies to the mechanics lien provision and only the mechanics lien provision. But we don't even need to go there because my brother's argument is essentially that there's an ambiguity in the lease and that because of this ambiguity, that he should be able to make the arguments he wants to make. But the case law in Massachusetts is pretty clear on this, that an attorney's fees provision, because it's in derogation of the common law, needs to be clear and unambiguous. And his own argument is that this provision is not clear and unambiguous. His argument is that it is ambiguous. And I would submit that that's just dispositive of this claim. There's a strong public policy in Massachusetts that is to limit attorney's fees. And it's stated in the Hayden v. Hayden case. In fact, the court, the SJC said that an award of counsel fees is one of great delicacy, and it's to be applied with caution. And it's difficult to conceive of anything more likely to undermine public confidence and respect for the administration of justice than the misapplication of attorney's fees provisions. And because of that, following that decision, the case law is clear that the provision needs to be clear and unambiguous. And the argument made by the appellant is just the opposite. He's arguing that this one is ambiguous. And because it's ambiguous, it should have been construed differently. So I would just submit that.
Well, he also seems to be arguing, at least in his brief, that the context of both Article 11 and Article 22 is to assure that the landlord is made whole whenever the tenant violates the contract. What do you say to that?
I'd say that's contrary to the express language, Your Honor. It's to make the landlord whole in the event that there's a breach of Article 11 of the lease. And there's reason to believe that that was a particular concern to these parties because there was a build out of the property that was a tenant specific build out that the trial court goes into great detail on and describes how there were windows that were fitted to the property and a unique space was created. And it's not at all a stretch to envision that in that circumstance where there is such a build out that mechanics liens would be a particular concern. And
it doesn't really make sense why that provision would be under 22 and not part of 11. Why would it go back and reference Article 11 when all of Article 22 has to do with rents?
I think that's why it actually had to say specifically Article 11 on this one.
Why wasn't it in Article 11, right? There's a couple provisions in Article 11. It should have been the last one. Costs associated with mechanics liens.
It could have been in Article 11, Your Honor. I'd submit that was possible. But the way these leases typically work is that sort of like the sort of these general sort of provisions that deal with remedies and such are typically placed together. And here they place the remedies together. And on this one specific remedy, it references back to Article 11 because it's basically saying this remedy only applies to that provision. But there are other references backwards within the text of the lease. And there's even an intentionally omitted clause. If you look at 2207, so what it looks like is that they were working with the landlord when he prepared the lease. And as the drafter, I would submit the lease should be construed against the drafter. But in any event, it's pretty clear that he was working off of a form because 2207 is intentionally omitted. So there was a clause in 2207 that the landlord took out and then in preparing lease. So I think in this one, the natural inference is because it was only to apply to the attorney's fees provision in this context was only to apply to Section 11, that language was added. That language was added, and the rest may have been stock language. That's what I'd submit likely happened here. But again, we don't have to go down that path because if there is an ambiguity, the case law is pretty clear that in the event of an ambiguity, there can't be a recovery of attorney's fees and costs because of the strong public policy that disfavors awards of attorney's fees in the absence of clear provisions. So turning to the issue of the alleged amounts, additional amounts that the landlord claims, essentially, I think that comes down to two components. There's the first component where the landlord claims that there was $17,900 essentially owed at the time of the lease closing. And then the landlord claims that there's an additional $80,000 that due in late fees. And that late fees, the landlord submits is both with respect to the 17 it claims was due at the closing and the 2015 CAM charges. Your Honor, I'd submit that there's ample evidence in the record that supports the trial court's conclusion with respect to the amounts, the lack of amounts that were owed at the time of the close of the lease.
So could I pause you on the 2015 CAM fees?
Certainly.
That is included in the judgment, right?
It is, Your Honor, absolutely.
And do I understand you correctly? Was a late fee for the 2015 CAM fees also included in the judgment?
No, it wasn't. It wasn't. And there's good reason why it wouldn't be, Your Honor. The 2015 is the last year of the lease. And so the lease provides that for the final year of the lease, that the bill for the CAM charges comes, let me grab the specific language for you, Your Honor, because
Well, you're basically saying they sued you before it was due.
they did. In fact, they sued us. You'll see the sequence goes that they sent out the statement for the fees, and then 1 day or 2 days later, they filed suit in small claims court. And according to their testimony, the notice was sent out by first-class mail. So it wouldn't even have been received at the point in time when the suit was filed. So there was no late fee that ever was triggered because they filed suit before they even assessed the fee. But in any event,
but why does but at some point it did become late.
It became sued upon immediately, and I guess if they hadn't filed suit and had they served a notice for the assessment of the late fee, and a notice is required to assess the late fee. It says upon demand, and then there's a notice provision in the lease that describes how a demand is made, and that was never sent here. The landlord never bothered to send the notice and demand on the late fee for the 2015 rent.
I suppose that what you're arguing is something along the lines of once they sued and sought to recover that amount in the lawsuit, they really couldn't claim that your failure to pay it absent a demand made it late.
I think that's right, Your Honor. And I do think that actually it is important that these notices be sent, and the lease requires them, that the late fee is to be assessed upon demand. The lease requires it. Counsel argues that the court somehow modified that provision, and the court did. The court said that it was not necessary to send notices by certified mail, but the court did not dispense with the requirement that notices and demands be sent by mail, by first-class mail. The court dispensed with the requirement that it be sent by certified mail. So it was the certification requirement that the court found was modified. The court never found that the provision that required a notice for assessments of late fees be in fact sent.
So the landlord seems to be arguing that the complaint itself somehow satisfied the notice requirement. What do you say to that?
Well, I would say, Your Honor, first off, if you actually look at the complaint that the landlord filed the day after they became due, or 2 days after the CAM notice was sent, if you look at that complaint, it does not claim these compounding late fees. It doesn't actually even claim a late fee on the 2015 CAM. Because of course he didn't claim a late fee on the 2015 CAM in that lawsuit that was filed in small claims court, because there was no lateness. He hadn't sent a demand for lateness. He had just sent the notice by first-class mail. It wasn't late. Because it wasn't late, there was no lateness alleged in the complaint. Then later on, in the context of the tenant's lawsuit, the landlord asserted a counterclaim, but of course that counterclaim was never sent by first-class mail to the address specified in the lease, because the counterclaim was sent to me. It was sent to counsel, and so that doesn't satisfy the requirements of the lease. The lease actually says the address to which the notice for the late fee needs to be mailed, and it's not my address, Your Honor. It's the address of Perimeter Brand Packaging. And there's nothing in the record to indicate that they ever sent an assessment of this late fee. And I think in this context, though, this is more than just sort of a, checking the box. This is an important requirement here that the tenant actually know what in fact is being claimed for late fees, because now we have this absurd claim that has no support in the record that basically late fees compound month to month, and that somehow now we've got multiple hundreds of times the amount of the initial the initial amount is now claimed as a late fee. I think in this circumstance, where the landlord's making such extreme claims, I think notices are all the more important, that the tenant actually knows what's at stake. And the lease requires it. The lease requires notices to be sent by first-class mail.
All right, I think we're gonna have to leave it there, given that your time has expired. Let me see if there are any other questions. No, it's an interesting case. Thank you both for your arguments. They've both been very helpful, and we appreciate it. And then I'll call the case. Yes.
I want to thank you for putting this off at 12:30.
It's our pleasure. It's no problem at all. It worked out for everybody. No problem.
Okay, waiting for the clock.
Case is now being recorded.
Okay. Good afternoon and welcome to this sitting of the Massachusetts Appeals Court, which is being conducted in this format because of the ongoing pandemic. Although it is being conducted in this format, the ordinary rules of oral argument in our court apply, including that each side gets only 15 minutes to argue with no rebuttal. I'm now going to call the case of LYNN DiPietro versus Bud Healey, case number 2020P0201. And Attorney Gordon, we're ready whenever you are.
I'm all set, thank you. As you know, this is the second appeal regarding the accounting of the conservator on this Bud Healey matter. The case was sent back because, among other things, there was no beginning values for the assets, and they weren't even listed in the inventory. And the inventory was not carried over to the account. Schedule C does not list any of the beginning assets, and the assets themselves had no value affixed to them as of the date of the appointment or of the date of the final accounting. So that we have no beginning and no ending values. We don't even have a complete listing of all the assets. As you can see, there were assets that were discussed and the disposition talked about, including the Jeep, the life insurance policy, and some other accounts that simply were not. There was a long-term care policy that just simply did not show up in the accounting, in the inventory, or in Schedule C of the accounting. Pardon?
Can't hear you, Justice Henry.
I was trying to defer to you to go, since we both seem to have a question at the exact same moment.
Okay, sorry. Attorney Gordon, was there any evidence in the record below as to what the defendant's assets were the day before the conservatorship?
The fiduciary did not produce any evidence of that. The only
but I'm not worried about the fiduciary. Did your client produce any evidence of his own assets the day before there was a conservatorship put in place?
What I did was I subpoenaed in records I was able to get a hold of, which were the AXA records for the policy and the TIAA CREF policy accounts. That's all that I was able to get a hold of, and that I subpoenaed in. Those were the only records that were brought into the trial on the well, there was no second evidentiary hearing. So
right, but presumably at the trial, the defendant could have introduced evidence of what his assets were before the conservatorship.
Well, we tried to do that. I mean, the problem was that the materials were not all readily available to him. As you know, the policy, the AXA policy, was converted by the wife to herself.
That was during the conservatorship, no?
Yes, it was during the conservatorship. After not only was she the conservator and used the conservatorship, but it was after her power of attorney had been revoked.
Right, but I'm asking a slightly different question and maybe the easiest way is to just say, why is it that he wouldn't know what his own assets were before the conservatorship?
we tried to do that as best we could. And that's why I subpoenaed in the records that I had, because I needed some values in order to establish what the accounts were, how much was in them, and where the money went. The primary, the Jeep, for example, he had no records remaining of that, and the vehicle was gone, and he never received any notice of the repossessions himself. That apparently all went to the wife, the ex-wife at that time. So I did what I could do with what I had to bring in the evidence and try to establish it. And that's why we have some of the information and some of the material that is in there involving the TIA, the AXA policy, and some of the other minor items that were, I consider them lesser value items than the major issues in this case. So I did that. As best I could, I did that.
But I didn't see any contention by the defendant that there were, beyond these, that there were additional accounts that he had before the conservatorship, or assets. He had additional assets than those that are ultimately a subject of the judge's decision here.
Right, but the issue is that during the trial, these other assets started coming out in her testimony, in the fiduciary's testimony. For example, the $11,250 cash transfer in the backyard came out during her testimony. The Jeep issue was brought up, and the only evidence regarding what happened to the Jeep was a very cryptic note in her check register that it was a repossession. I couldn't locate any documents showing it was repossessed, for example.
Yeah, but I'm not really asking about what happened during the conservatorship. I'm asking about before the conservatorship.
I did not have, we did not have the complete records, and I did what I could with what I had.
Okay, so your own client was not able to put forward evidence of what his estate consisted of at the day, let's say, as of the day before the conservatorship.
I don't think we exactly did that. I would have to say there's some very broad testimony about what there was and what there wasn't. But he hadn't had access to anything for over, at that point, well over a year. And the ex-wife had put him into that facility at Emeritus, for which he had no contact with anybody until his sister removed him. So that was sort of an impediment to trying to do that. And the burden was on the fiduciary to provide an account, an inventory, and then Schedule C, statement of what assets she came into possession of at the time she became the conservator, on top of which she testified at the trial that she was aware of all these assets, the AXA account, the TIA, CREF, and IRA account, which unfortunately I was unable to track down what happened to it.
Counsel, you said, let's just talk about the life insurance policy for a moment, though,
okay.
Because do you all agree that it had a cash value of a certain amount of money?
You broke up. You there?
Do you agree that the life insurance policy has a cash value of a certain amount of money?
I can say that the cash value at the outset was probably around $15,000 and change. The cash value in September of 2013. There appear to have been additions to the policy, taking it up to at some point around $36,000. And then in January before the trial, the value appeared to be around $18,000 of cash value. So there was an $18,000, actually closer to $21,000 loss in the cash value.
Well, but the judge ended up coming up with the cash value. So why, if your client receives that cash value, why is the insurance policy, the life insurance policy, not accounted for?
Well, The value she came up with was in August of 2014. And there's no way measuring of the values because it's claimed that it was over $20,000 put into the account, which would have taken it up to $36,000. And frankly, the $22,000 that she finds in there doesn't make any sense in all the surrounding information that's there. The biggest problem with the policy is that there was a conflicting order in the judgment that he was to get it back, but then he wasn't to get it back, and he never conveyed the policy, and there was never any transaction that gave her ownership of that policy. And one of the things that he wants is he wants that policy reconveyed to his ownership. It's always been his. It was never hers. It was never transferred to her, even in the divorce. She didn't get it. So, that policy has value to him because he can sell it. He's 69 years of age right now. He
Right,
can sell that policy.
Counsel, does the policy have value to him besides the cash value?
Yes. He can,
What?
I didn't hear you.
What is that value?
He can sell that policy.
That's cash value.
No, that's not cash value. I can't hear you.
Yeah, Justice Henry, you're blanking out. But
I didn't say anything. You're saying there's cash value. There's some value besides what he can sell it for, and I'm trying to find out what that is.
There's the cash value which the insurance company would pay him on the policy, which was $15,000 at approximately September of 2013. The other value to the policy is because of his age, he can sell that basically to a factor and collect. It would sell the policy. They would then take over the policy. They would give him, at his age, probably into the six figures for that policy. And on his death, the balance of the value of the policy would go to whoever the arbitrage or factor person was. So
right. That depends on his changing the beneficiary, correct?
No, it doesn't. Well, he would. He could change the beneficiary to the.
If the beneficiary remained his daughter, how would the factor make any money?
Well, he'd have to, once he had the ownership of the policy, he can change the beneficiary.
Exactly.
Right now he has no.
So I have a question. So what you're really saying is the value to him is the right to change the beneficiary.
Basically, yeah.
Right. When was the policy obtained?
Oh, that was back in the 80s, I believe.
All right, and that was and have the beneficiaries changed over time?
Well, they did after the ex-wife put it into her trust and made the two children the beneficiaries of the policy on that revocable, the inter vivos revocable trust. She designated the beneficiaries of the policy.
Who were the beneficiaries before that?
I believe she was.
She was. So the change was that she changed it from herself to their children.
Right. I mean, they both had policies. In her testimony was they both bought policies at the same time. He was a beneficiary of hers and she was a beneficiary of his. And she did not get the policy in the divorce. So, he had the right he could change the policy beneficiaries, especially to his sisters or anybody else, but he can't do that now because the company won't recognize his right to do so. In fact, I contacted the company to try to do that, and they list her as the owner of the policy and won't even give me any, even with a release from him, will not provide me with any information on the policy. So, I mean, that policy has a six-figure value to Bud Healey, who could very conveniently use that money to support himself at this point in time. So that's, I hate to say the major issue, but it's a big issue in this case. And from what my argument in the brief is, she had no right to the policy. Basically, she converted it, she embezzled it, and
so if we were to agree with you, then I take it all the money that was ordered to be paid by the conservator over to your client for the value of that policy would have to be paid back.
Well, except the cash, you got to separate out the cash value that accrued with the payment of the premiums. So what she did was, apparently she took over $20,000, we're guessing, out of the TIAA policy or account, paid it into the cash value of the life insurance policy, plus some other additions, which took it up to $36,000. So that's one value. The other, so and by the time this thing got closed out, that had dropped down to 20, somewhere, there was around an $18,000 loss in the cash value, which was his money from the TIAA craft account that had been left in that account. It would have been $20,000. So you have two elements of the value of the policy.
But conceptually, setting aside the math, if we were to agree with you in terms of the ownership of the policy, there would need to be a return of monies to the conservator.
No, it was Bud Healey's money that went into that policy. According to what her claim is, she cashed out the TIAA account. She took $20,000 of his account money and put it into his life insurance policy. So it's his money. She did not take her own money and put it into the account.
But counsel, I think what you're trying to say is that it's your client's choice whether he gets paid the cash value of the policy or if he just gets the policy back, right?
Right. Well, if it were a perfect world, you get the policy back with the cash value at the time of the conservatorship in September of 2013, which would be about $15,000 and change. That would be what should happen. But the problem is that $20,000, from what we can gather, of his own money went into that policy. So the policy had 35 plus it was. If you go through the accounting, you'll see that there was some other payments made out of his money into the policy, another few $100, another $1,000 here and there. But that was his money that went into it. So that was not her personal funds.
And you're saying that is he competent now? Does he have a conservator now, or is he representing himself?
No, he does not have a conservator. If he has,
and so you're saying it's his choice now whether to change his beneficiary on that policy.
Right. He has that. He should have that right. Correct. To do it. I mean, he's going to do it. I mean, the reality is the children have not seen him in over 7 years. They made no effort to contact him, from what I can understand. So he would definitely be changing. As a matter of fact, I contacted the company to try to get the beneficiaries changed, and they refused. They wouldn't. They would have. They said he's not the owner. I can't do it. So.
Great. Unless there are further questions.
I do have one question.
Yes.
And that's just on your general overall point that there was never an adequate statement of what the conservatorship existed of at the beginning.
Correct.
And because of that, we can't have any certainty of what's going on here, that the accounting should be disallowed.
That's my general.
What's the practical? I mean, we understand that after remand, the judge made considerable changes to from the earlier decision. But if the accounting is disallowed in practical terms, what would that mean for you?
That would mean he would get the insurance policy back. That's a big deal to him. The amounts that the TIAA craft, that would be based on what we have, a $39,000 credit to him, 39 and change. The Jeep would go back to him at $11,250. I agreed in the brief with a number of the items that would disallow, which leaves us the AXA policy, the Jeep. He wants his uncle's racing memorabilia back that she refuses to turn over. This may seem small to you, but it's you know. It's,
do we have sufficient information in this record on that issue?
She has it. I can, if I had a trial, I could establish what the items were on that issue because there is evidence out there. So, and that was, you know, that was one of the reasons I thought we needed at least some sort of evidentiary hearing on this. We either somehow establish, have the court establish what the starting point was in September of 2013, or order a new proper accounting, which I never got the opportunity to do.
Well, you had a trial once.
Right, but that was, you know, the problem with the schedules were that they weren't done properly, and you know, on appeal, you know, the reference was made to the Murray case and what was required under the Murray case. And schedule, you look at Schedule C and Schedule D of this accounting, they just don't comply with the requirements under Murray, and we don't know what there was, and frankly, I don't know what she did. I'm not an accountant, and the only way you can unravel this is, as I said in the brief, was with a forensic accountant to try to figure out what happened if he had some records, and she has no records. She you know, she doesn't. She destroyed them. You know, she's very obtuse on what happened to the records. So we don't have the bank records. We don't even have a, you know, a real checking account or her conservator records.
Okay, we're gonna have to leave it there. Your time has expired, but let me check to see if there are any further questions. No. All right, Attorney Anthony.
Thank you. Good afternoon, Your Honors. May it please the court, Christine Anthony for LYNN DiPietro. Your Honors, after this court issued the memorandum and order pursuant to Rule 128 on Mr. Healey's appeal of the decree issued that allowed the first and final accounting of my client as conservator, it vacated that decree, Judge, Your Honors, and the trial court judge was thus required to enter a decree after rescript, which was consistent with the memorandum and order and which conformed to the rescript. And that is precisely what occurred. And for that reason, Ms. DiPietro is respectfully requesting that this court affirm the decree after rescript and order the payment of her attorney's fees related to the appeal.
So,
the trial court—
Counsel, where is the AXA life insurance policy right now?
My understanding, Your Honor, after the trial is that it is with my client in her inter vivos trust with the daughter named the beneficiary.
And what I'm trying to understand is where in the history of our precedent have we ever said someone took something wrongfully and then they got to choose whether they gave it back or whether they paid some money instead?
What I would say, Your Honor, is that the judge in the first decree gave Ms. DiPietro that option, the option of either retaining the life insurance policy or paying the value of it to Mr. Healey. And the appeals court examined that issue and issued a judgment after rescript. And never in that judgment did the court indicate to the trial court judge that she did not have the ability or the authority to do that.
Right, but there are two different values, it seems to me. And then there's also something that's not necessarily a monetary value, but a value nonetheless. The two different values are the present value, the cash value of the policy. And then there's a value of the policy after the condition of the person, you know, the person dies. And which I guess is maybe the face value of the policy. And that also can be monetized. The value of that can be monetized. It's different when the person whose life is insured is 22 versus 102. So it doesn't look to me, and I hope you'll correct me if I'm wrong, that latter value was anywhere assessed in either the first proceeding before the first remand, the first trial, or on remand. Am I correct about that?
I believe that I would agree with you, Your Honor.
Okay. And then the second thing that is a value, it seems to me, in a life insurance policy is the ability to determine who the beneficiaries are upon one's own death. So in other words, the ability to decide who gets life insurance policies upon one's death. We certainly know that that can be determined by a court. For example, in custody, divorce proceedings or custody proceedings, a court can order who a life insurance policy should be held for. But absent that, do you have any authority for the fact that someone else can decide who the beneficiary is of a other person's life insurance policy?
What I would say, Your Honor, is that the trial court had assigned the policy, didn't assign the policy, but my client had possession of the policy, and the court allowed her to retain that policy in her inter vivos trust at her election, both in the first decree and the second decree. And in the first decree, Judge, that issue was briefed and argued to the appeals court, and the appeals court passed on issuing an order in the 128 decision to the trial court mandating that she make a different order in the decree. And I believe that we have to take into consideration that 128 order was issued after deliberate reasoning of the appeals court.
Sure, but what's on appeal now is a new judgment. That's what's before us. Is this new?
She got muted. The attorney got muted.
Oh,
I got muted. I'm sorry. Thank you.
What's on appeal now is a new judgment.
It is a new judgment. Yes, Your Honor, that was issued after rescript and that the court entered consistent with the provisions of the.
So are you arguing collateral estoppel on this insurance issue?
Judge, I believe that this is, if you will, a second bite at the apple, because
I guess you're arguing law of the case.
The appeals court did not issue any instructions to the probate court judge that would mandate that she enter in her decree that the policy go back.
Counsel, the appeals court vacated, right? But it didn't piece by piece indicate every piece of the prior judgment that was in error. It was vacated completely with instructions to use proper standards, make proper findings, all of this. But can you look at the opinion and tell us that this issue was specifically decided?
Well, the court, what I would suggest is that at the end of the opinion, it orders the trial court judge to enter a new decree that's consistent with the terms of the memorandum. And
sure, you may be misreading that. That does not mandate anything in particular. It just says don't do anything inconsistent with this. It doesn't do much beyond that, I don't think. I think that's Justice Singh's question to you.
Yes. What I would say is that the court in the decree, in the 128 decision did address the issue of the life insurance policy and didn't comment or make any other orders or findings relative to the propriety of allowing Ms. DiPietro to maintain ownership of the policy. And I would also suggest that the issues that Attorney Gordon is raising today on behalf of Mr. Healey with respect to the value of the life insurance policy or the ability to name a different beneficiary was not argued in the trial court in the first trial and was not argued in his brief. There is no evidence that the life insurance policy has any value beyond the cash surrender value because no evidence was presented to the court.
Who had the burden on that? Isn't it your client to establish both the starting and the ending values and the disposition of everything during the period of conservatorship?
The burden is certainly on her to, as you indicated, to provide the accounting to the court that has the proper value of assets and also of the charges that she has made against the monies that have come into her possession.
So is there any restriction currently on your client's ability to change the beneficiary on the life insurance?
I'm not aware of that, Your Honor. To my knowledge, no, but I couldn't say for certain on that
Or
issue.
is there any restriction on your client from selling the, you know, the future value of the benefit of the future value on the policy to a third party?
None that I'm aware of, Your Honor.
All right.
So he mentions a long-term care insurance policy that's somehow not accounted for. Do you have any position on that?
I don't have a position on that. It's my recollection of the judge's findings that the issue of that long-term care policy was, I believe, mentioned in the trial, but I don't think there was any evidence produced by either side as to the existence or the disposition of a long-term care policy. So I don't have any knowledge of that. So Mr. Healey, having not briefed the issue of what might be the value of the life insurance policy, and having not brought any of that information or valuation issues before the trial court, respectfully, I don't think should be considered by the appeals court at this time. What I would add with respect to the question about whether or not there should have been a trial, the trial court judge specifically found that she had sufficient information to reevaluate the accounting of Ms. DiPietro, and that she was able, from the information from the trial, both through the testimony and the exhibits, to identify the assets that had come under Ms. DiPietro's control, and that she was able to examine each of the charge that Ms. DiPietro made on those accounts.
But was there ever a point where we can say what actually came into the hands of the conservator at the beginning? What was the value?
So at the beginning, and I assume, Your Honor, that you're referring to when she was appointed the conservator in September of 2013, she ultimately filed an inventory that the trial court judge found did not have all of the assets that had come under her control at the time that she was appointed conservator. And remembering that an inventory is really a snapshot in time under the statute. It's the assets that come into a conservator's control at the time that she was appointed. So what was clearly missing from the inventory was, and the trial court found this, was the issue of the Jeep, as well as the life insurance policy that was in existence at the time that she became conservator.
So am I correct in understanding, and this seems like perhaps a systemic failure, that when someone is appointed a conservator, they do not have to produce a beginning inventory immediately so that they understand everybody's watching them?
The statute requires that the inventory be filed within 90 days of a person's appointment.
And did that happen here?
That did not happen. It happened sometime after.
Well, it was an ending inventory, in fact.
So an inventory is meant to be those assets that the conservator could reasonably identify at the time that she was appointed. So that would have been September of 2013. It's not unusual when someone's appointed a conservator that throughout the course of the conservatorship that he or she might become aware of other assets that he or she did not know at the time that of the appointment. So, and that's where those assets, if you will, get added to the accounting.
But here it wasn't even filed.
It was filed approximately, I believe, around 11 months after her appointment. So it was not filed.
At the end. Essentially at the end. It was an ending inventory instead of a beginning inventory. Isn't that problematic in being able to assess whether the conservator properly discharged her duties?
The inventory, again, is just a starting point. And when a person when a conservator or guardian files an inventory, there's no ability for a person to object to the inventory. The ability to object comes at the time of the accounting. And so the accounting is where the assets are meant to be set forth. And in this case, clearly all of the assets were not set forth in the inventory or the accounting. But the trial court judge in this second, after remand, she identified the assets that had come into possession of Ms. DiPietro. And it's through really the disallowance of the account or the changes to the account that the trial court judge made that then brought everything together so that Mr. Healey was made whole by the second decree after remand that the trial court judge entered. She disallowed many of Ms. DiPietro's charges to the account, and she also had her pay back certain sums when she found, for example, that although it was credible that she gave Mr. Healey cash, that he was not competent to accept that cash.
So counsel, the document, and I'm looking just right now at record 62, I mean, it says there was a long-term care insurance policy in place. That was what allowed the placement of Mr. Healey into emeritus. So then if subsequently the judgment doesn't say anything about that long-term care policy, shouldn't we be concerned about that?
The long-term care policy, I didn't see anything in the findings that indicated that the policy was in existence at the time that she became conservator, although there's a reference to that. I don't have any documents or information on that to comment.
If we were to conclude, has the second judgment been satisfied? Has your client paid the monies?
My client provided Mr. Healey through counsel a certified check for the funds required, and it was returned to me by Attorney Gordon. So she made the attempt to do that, and it was not accepted by Mr. Healey through his counsel. So she did attempt to make full satisfaction under the decree. And if there are no further questions,
let me
I
check.
would rest.
Nope, I don't see any. It's a very interesting case. We've been helped by your argument and we appreciate it. And the case is now submitted. Thank you both.